given. What is the can be responded to? Can be responded to? Just take instructions. We'll just take instructions.
Just ask somebody there. Somebody there. I hope
yes.
I don't take this.
Only thought Mrs. Gawai's, we can give a healing touch to Mrs. Gawai's.
Lord, I was to answer Lord, those two questions which I said that I will give a detailed answer Lord, on the elections Lord.
Yes.
Lord, so far,
I'm sorry, Malad.
I didn't want to. I was not unmuted. I've been very kindly allowed by Mr. Dwivedi to come in after the attorney because I have some personal difficulty on tomorrow.
Yes, Lord. Mr. Salve had some difficulty, Lord, and Mr. Dwivedi was really gracious. Really gracious, Lord, that he didn't object, and I'm really all thankful.
That's a matter of internal adjustment for all of you. Now, Mr. Solicitor, what do you have to?
Yes, Lord, on the question of your Lordship's first question, when the elections can be held. Well, the central government response is, Lord, the central government is ready for elections at any time now. But till date, but updating of the voters list was going on, my lord, which is substantially over, my lord. Some part is remaining that election commission is doing. But we are, I'm sorry.
Yes.
But when would be the call taken by the State Election Commission and, of course, my lord, Union Election Commission together? But there are 3 elections which are due.
Yes.
Lord, for the first time, the 3-tier Panchayat Raj system is introduced after 2019. So the first election will be that of Panchayats. District Development Council elections have already taken place. But Panchayat institutions, that is for the rural areas, your lordships are aware, under Chapter 9 and Chapter 9A of the Constitution.
Yes.
Lord, your lordships, I informed your lordships that the Leh part elections are over. Kargil for the Hill Development Council election is at the end of this month. The process is on, and the election is, I think, 2012 this month, 2023.
For Kargil also, you call it the Hill Development Council.
Hill Development Council.
For both, you call it.
For both Kargil and Leh. These are the only 2 parts in Ladakh UT. Lord, this is the position as on today. And the second election would be municipality elections. And the third would be legislative assembly elections. It's UT with legislature, my lord. Your lordships were taken through that, my lord, except 2 subjects, law and order and police. Look, this is based upon the figures which we have. The terrorist initiated instances are reduced by 45.2%. I'm comparing 2018 situation with 2023 situation.
Nothing to do.
Lord, infiltration, which was a very major problem in Jammu and Kashmir, reduced by 90.2%, 90. In law and order events, substantially the stone pelting and other events, reduced by 97.2%. These are all figures relevant for the purpose of decision, my lord.
Minister, this is not for our purposes really relevant. The only
No,
one
for the purpose of, my lord, when to hold the election. As on date, this is the position. That's what I am pointing out, my lord. And these are, everything is on, my lord, affidavit. I am not. And security persons casualty is, my lord, reduced by 65.9%. These are the factors, my lord, which agencies would take into consideration. But fortunately, affected the elections most were stone pelting incidents and regular call of bandh or hartals. My lord, means hospitals, schools, every institution, my lord, where a common man is concerned. Lord, from 2018, in 2018, the stone pelting was 1767. It is nil now. Not just because of effective policing or security personnel, but because of various steps, my lord, like gainfully employing the youth, etc. My lord, they were misled by the secessionist forces, by the forces, my lord, outside the country, etc. And organized bandhs, which were in 2852 instances, organized bandh, call of bandh by secessionist forces. Nil.
How many? How many?
In 18, they were 52. Now, it is nil. Now, Lord, so far as statehood is concerned, Lord, I have already made a statement before your lordships, but that apart, the statement of the Honorable Home Minister on the floor of the House, that UT is a temporary phenomenon. We are dealing with an extremely extraordinary situation. The state will have to be infused with several things so that it becomes a state, so to say. Lord, those actions, my lord, are initiated. And Lord, I may give some, my lord, instances how it is progressing, my lord, to become a state, because I am unable to give, my lord, exact.
You can wrap up in about 2 minutes now. You can tell us.
I'll just, my lord, give me 2 minutes. Your lordship did not write. I'll place it on record. Lord, for the purpose of ensuring that the UT becomes complete state, my lord, as it should have been like any other states, the central sector scheme investment is 28,400 crore. The investment proposals from other than central schemes is 78,000 crores. And till date, the actual investment made is 2,153 crores. Your lordship did not write. I'll write it down and, my lord, and give it to your lordships. Lord, several initiatives have taken place, and as a result of which the transparency, Lord, has shown us that the projects have risen from, and these are all, my lord, statements on affidavit I have made, 9,229 in 2018, and now in 2023, it is 92,560. More and more people are participating in e-tendering and several e-initiatives, my lord. And therefore, my lord, that is also giving a boost, and the youth is gainfully employed. My lord, the peace doesn't come merely by police action. There are several schemes which are introduced, several beneficial projects which are introduced. I'm just giving a bird's eye view, my lord. And out of 53 projects under the Prime Minister Development Package, worth 58,477 crores, out of 53, 32 are completed. This is how progressively, my lord, we are proceeding to make it a complete state. But I am unable to give, my lord, my instructions are the exact time period right now about the complete statehood, while saying that union territory status is a temporary status because of the peculiar circumstances the state had passed through with repeated and consistent disturbances of decades. Well, it might take some time, and we have shown, my lord, the progress also. It was heartening for me also to note that only in 2022, January 22 to December 22, 1.88 crores tourists visited. The lordships are aware the main industry so far was tourism in Jammu and Kashmir. Now, my lord, industries are coming. And till date in 2023, 1 crore tourists. It gives employment, it generates employment in various sectors. My lord, one, there is a tourism boom. So these are the steps which are being taken by the central government, which can be taken only if there is a union territory. And I have shown the Reorganization Act. It is having all trappings of the state. But the election, the government is ready. It is for the Election Commission of India and Election Commission of the state to take the call. Out of three, which election to take place first and how. The updating of the voters list is complete. Some part is missing, but it is yet to be over. It's in the process. It would be over, my lord, in a month or so, my lord. That's what I'm told. Thereafter, my lord, they will take a call considering the overall situation.
You'll be wondering what the Chief Justice is doing is on a phone from the court.
Yes. This is my question. Learning attorney will assist.
But I just want to know whether your lordships are taking into account these facts, because whether that's extremely relevant from our point of view. Because if your lordships had said earlier that subsequent facts will not be taken into account, we are dealing with the law, we are dealing with these facts.
Mr. Sibal, these facts on what they have said would have possibly no bearing on the constitutional issue which has been argued.
But even otherwise,
But-
because we have to counter those facts, Mullah.
We had asked them a question on the roadmap for holding an election.
That's fine, Mullah.
That's what they have responded.
But Mullah,
That's not, Malad, in my
But that
argument
has-
on merit.
But our decision on the constitutional issue has to be on constitutional.
but
validity.
Mullah, these facts will go into the mind of the court because they are trying to show as to how this enormous change has taken place for the benefit of the people of Jammu and Kashmir. If you have 5,000 people under house arrest and 144 throughout the state, there can be no bun. So Mullah, let's not, my request to your lordships is, please don't enter into this arena because we will have to counter it with all kinds of facts, Mullah, which I don't think is necessary for this court.
The nature of the development work which the government says has taken place post August 2019, this may not be of relevance to your constitutional challenge. And therefore, when they respond to the constitutional challenge, that has to be dealt with independent.
I didn't rely upon it
But,
while
Mullah,
answering on
these
merit.
facts, if they come into your lordships, Mullah, as part of the record, then that has.
I think, Mr. Sibal, what the solicitor, to be fair to the solicitor, what the solicitor was saying is that the roadmap to full statehood would take a little time.
That's obvious.
Right now, that they are the development. There, his submission is that right now development work is taking place. Some stability has to be brought about. This is not a permanent arrangement, namely the UT status. They envisage that it will be a movement from UT to statehood again. We can't give you a fixed point of time when we will restore statehood, but they have told us the process which they are following on the path to.
I have no objection to
That-
that. That statement, I have no objection.
And that's how we read it.
Yes,
actually.
but if any other fact that you bring to your lordship's notice has no bearing, because I'll have to count.
Mr. Solicitor, Mr. Attorney, we take it that
Everybody like-
what you said, Solicitor, a short while back, is along the lines what we said.
Yes, yes,
That
but
this is-
answer the election and
The roadmap to
statehood
full-
query, not as a
Correct. I have
justification
no
for.
problems to that,
And
Mullah.
Mr. Sibal also fairly says that he has no difficulty about that.
But
During my
he says
arguments
that
on merits,
this
I
has
never
happened.
relied upon.
This cannot be an answer to the constitutional challenge.
Let me-
But
let
even
me-
otherwise, it should
I
not
also,
speak
Mullah,
into your
didn't,
lordship's
I
mind,
would-
Mullah, that these are great things that are happening, Mullah, because today, the kind of drugs that are
one
happening
second.
with the youth in Jammu Kashmir is unbelievable. But I don't want to enter into that
Can I
controversy.
put it like this?
The
Neither,
unemployment rate is enormous.
Mr. Sibal, these are matters on which there can be and should be in a democracy policy differences,
That's right.
but that can't affect the constitutional
Absolutely.
answer to a
Therefore,
constitutional
Mullah,
challenge.
once you start placing these facts and Mullah, your lordship.
But therefore, we place those facts which he mentioned in the perspective of the roadmap to statehood. That's all, and nothing on.
This is
on
not
the-
a justification.
This is not a justification. It cannot be, from our perspective also, to the answer to the constitutional challenge. We'll have to address the constitutional
So your
challenge. on
lordship will
constitutional
allow me to
grounds.
place some counterfacts to that?
may
No,
I
it's
put
not
it like this?
necessary,
But
Mr.
I had intervened that stage also when you
Yeah.
were saying, only for this reason that we wanted in a conspectus to understand when they look to a restoration of statehood.
No
To
problem.
which they made a statement that
That's no issue, Mullah. They say that will take some time. Your lordships will decide on that issue, Mullah.
And
decide
that's
what it is
confined to
apart.
our answer, our question to Mr.
But
Solicitor.
Bunds
are very
have been
clear
reduced
on
to
this.
zero, bunds have
Neither-
been reduced to
but
zero,
Mr.
all
Sibal, if
that,
you don't
much.
mind.
With respect, I say, your lordship should not even, those facts are not relevant for the purposes of your lordship's decision is all that I
And
say.
therefore, we had not taken that additional
Right.
affidavit which was sought to be filed at the inception of the record, and I don't think there's been any change in that.
Deeply.
position.
I think it's better understood like this. Neither these statements nor their refutation, if need be, will enter into the question of determining the constitutional validity.
Correct.
So therefore, paraphrase it like that.
Yeah.
You don't want to put it like
And
that.
on that
Kindly
aspect,
speak.
I also
on
didn't
that-
rely.
On that,
Kindly
Mr.
speak.
Sibal, Mr.
It's for an
Attorney and Mr.
entirely different
Solicitor,
purpose.
I think there's a broad-based understanding on both sides that the constitutional challenge has to be answered on.
But
During my assistance on merits, I never relied upon
The
this.
problem is the following, these are televised, all this is being televised and all of this being recorded. So Mullah, these facts come on the record, they are part of the public space and people feel what a great thing has been done by the government. Mullah, this creates a problem. Well, that's why I.
That's why progress never creates problem.
I'm sorry.
Lack
Please
of
allow me.
offenses
All right,
do
Mr.
not
Sibal, we
create
got your
problem.
point. We got your point. I think we have clarified it.
Yes.
That the constitutional challenge will be dealt with by the Supreme Court on constitutional grounds.
That's right. None of this should enter into the.
And they have not argued equity in defense to your constitutional
That's all,
challenge.
that's all, Mother, that's all.
Yes.
I suppose these statements are otherwise in the public domain.
No,
In elections,
there's a
will
lot
be
in the
held,
public
people are
domain.
meeting it all, and therefore,
Mr. Attorney,
public
there's a
will
lot-
consume it.
Mr.
because
Attorney
of-
General, you're meeting the constitutional challenge on constitutional argument.
Which I did.
We must
but I never-
address this matter like any other constitutional
That's-
matter as a
that's right. In the
constitutional issue
public
which we have to
domain, I
confront.
can face a lot of facts.
But when I answer the question of election and the statehood, these figures will go into our
So
decision.
that you may, that's not part of the public
And
space.
that
You
Mr.
can-
Sibal
you-
has also clarified, there can't be any
That's
objection.
internal.
We needn't labor this issue, we are all now clear
Yes, yes.
on conceptual grounds. Mr. Attorney, now we'll hear you.
Please, Your Lordship. And one is reminded of Dworkin's very deep engagement on the hard cases and not one single.
Only
Yes,
one
yes, yes.
interruption, Murad, on the lighter side. My learned friend said that there are some people who are under house arrest and therefore there is no bond. But that means the right people are in the house arrest.
5,000 people. Let's not make
It's
a,
not that.
let's make a mockery of democracy.
People are under house arrest.
5,000 people were under house arrest at that time. 144 was throughout the state. This court, Manadina judgment has recognized that. Well, the internet was shut down and then they are saying there were no buns. Why, how can there be buns when people can't even go to hospital? People could not go to hospital because of the bun.
I
People
wish-
died.
I wish,
A single.
Let's not go into all this.
Mr.
I
Sibal.
wish we don't enter into
one
this
second.
dialogue.
Mr. Attorney,
I-
Mr. Sibal, we have, right from the inception of the hearing, we have heard this matter in a sense of dispassionateness,
Absolutely.
the sense of objectivity which must govern an answer to a constitutional challenge. We request both sides. Let's maintain it at that level.
Absolutely.
Because, yes. Yes,
I don't
Mr.
think
Attorney.
neither the solicitor nor me has entered into the domain to try to color the mind of the judges. We've not done that. I don't know about that.
All right. Yes, Mr. Attorney.
As I say that the famous principle versus rules and the hard cases thesis of Dworkin, one wonders we are not in a situation like this. We're taking off from where I left day before yesterday. There's a couple of digressions I would like to probably play before a lot before I. Because when you talk about the intent of a law, Wittgenstein, who co-authored with Bertrand Russell, and his famous philosophical investigation, he talks about a signpost. How do we know what a signpost means? There must be a practice of using the signpost and an understanding which develops over the using of the signpost. Without that practice and understanding, the signpost means nothing. So this principle has been used in various circumstances to bring closer. If there is an understanding about a law on the basis of a practice, then interpretation follows one course, one trajectory. But if there is a lack of understanding or conflict of understanding, interpretation heads in another trajectory. Therefore, when you are trying to understand the intent and connect with the content of Article 370, you have to keep in mind what went into the original author's making of 370 and what has happened over a period of time by the practice of using Article 370. So, a text sometimes, by reason of its aging and the use of the text, may demonstrate a certain practice which may show in a slightly different direction. That's why in the context of desuetude, two important principles come. A disuse plus a contrary practice. I don't get into the desuetude doctrine, it's not necessary for a purpose. I don't want to flag that. So when you're trying to understand 370 in a perspective, we have all these complexities. It's not merely a case of reading the text, looking at the text and the context and arriving at a meaning. We are confounded by the practice of Article 370. whether in conformity with the original intent or in deviation from it. So the court is now called upon to look at the age of the text and the use of the text and how in current times the president understands both the original text and the use of the text, and the president now understands this is what I would like to do with the text. So I left day for a study on this proposition when the president is not precluded for what I call the taking stock of what Article 370 has done over a period of time. This taking stock is written into Article 370. So while we do that, how the president may take stock and how the court will be called upon to have a glimpse of understanding of what the president intend to by taking stock. I just want to place 5-6 propositions in the context of concession against absurdity. These are all gathered from books on interpretation of statutes. Because the presumption against absurdity will, number one, avoid an impossible result.
Presumption.
It will also avoid an unworkable or impracticable result. I'll put them all together and hand it to your lordships now. And it will also avoid an anomalous or illogical result. And connected to that is to avoid a futile or a pointless result.
What is the third one you said, Mr. Attorney?
First one is
No,
an impossible result.
no, third one.
Third one, an inconvenient result. An anomalous or illogical result. An anomalous or illogical result. And the final one, I said a futile or a pointless result. All these will go into courts looking again the presumption against absurdity. So court will avoid a construction that requires a person who that which is impossible. The doctrine of impossible is contracted is different, but when it comes to textual impossibility or constitutional text, it may stand on a different footing. That's why all these principles have a certain importance in construing Article 370. I referred briefly the other day about this presidential poll judgment of your lordships. That is 1974 to SCC 33. Before I take a lordship of the 1974, it is a 143 reference in the context of holding elections. Before I take your lordship with that, let me make a few observations. It's not part of the PDF because it's not part of the compilation.
Yes.
So we are trying to look at the proviso to clause 3 of Article 370.
So which is the part of this judgment you want us to see?
I'll give the paragraphs, your lordships.
We have it opened up and you have it on the screen.
Yeah, we have paragraphs. I'll just summarize the proposition was the presidential election had to be held. Gujarat Assembly was dissolved. Therefore, the Electoral College was incomplete. So the argument was, without the Electoral College become incomplete, you can't hold a presidential election. Court says they read Articles 55, 54, etc., and come to a conclusion. It's a mandate that you must hold the election before the president term expires. Therefore, the lack of the Electoral College not being complete will not come in the way. So that unless you fulfill that impossible, that the court says you must, the argument was, you must have the Electoral College completed before you hold the elections. Therefore, the mandate of holding the election.
You're stretching that to our case because According to you, the conditions for the application of the proviso to Article 373 are absent, and therefore the substantive part cannot be rendered into disuse merely because of the
You're
absence of a
absolutely
Constituent
right.
Assembly.
Therefore, I come to the arguments on the other side currently. Now, there is no principle in
What's the para?
jurisprudence.
Just give us a small para so we are then done with this judgment.
These paragraphs 5, 4, 5, 12, 13, 15, 20, 21, 29, and 47. So there they look at the impossibility of performance.
How
So what I'm
do
trying,
they formulate it? Just let's see it in a moment.
I'll presently come to it.
It's 7 judges, so we can just look at maybe that one or two sentences and how they formulate it.
Give me paragraph. You'll also just see paragraph 4 and 5. Paragraph 4 at page 47 of the running page 47 of the judgment. So they come to a conclusion that the conclusion part of paragraph 4, it shows that the time to hold an election to fill a vacancy is also mandatory in character. Then,
Actually, the
paragraph 15, that's important for our purposes.
Some of this suggests. So the state of Jammu.
Page 49, running page 49 of the judgment, paragraph 14, last sentence, and then thereafter paragraph 15. Paragraph 14, the last sentence. Sentence beginning, the necessity. No, Justice Scholars got that paragraph.
Only 26 pages.
Stop you from. Strike all that.
Paragraph 14, last
49,
last sentence.
page 49.
The sentence beginning the necessity for completing the election.
14
Yes.
Before the expiration, the term is enjoined by the Constitution, public and state interests, and to see that the governance of the country is not paralyzed by non-compliance with the provision that there shall be a President of India. Next paragraph. The impossibility of the completion of the election to fill the vacancy in the office of the President before the expiration of the term to office in the case of so-and-so, as may appear from Section 7 of the 1952 Act, does not rob Article 62(1) of its mandatory character. The maxim of law impotentiae excutat legem is intimately connected with another maxim of law, lex non cogita impossibilia. Impotentiae excutat legem is that when there is a necessity or invincible disability to perform the mandatory part of the law, that impotentiae excuses. The law does not compel one to do that which one cannot possibly perform. So I cannot possibly resurrect the Constituent Assembly and say, I want your opinion on this matter. So therefore, when it appears that the performance of the formalities prescribed by a statute has been rendered impossible by circumstances over which the persons interested has no control, like the act of God, circumstance will be taken as a valid excuse, so and so, etc. So it has two aspects. One, you are relieved from performance. You are also relieved from performance the way it commands you to perform.
Say it's like an.
Yes.
29. Paragraph 21. And an argument that it shall not be done is available in paragraph 21. Your Lordship, of paragraph 21. The interveners submitted that the units of the Electoral College were House of Parliament and the Legislative Assembly of the state. Johnson submitted that the democratic character of the Constitution demanded that there should be elected members of the Legislative Assembly of the states to be entitled to cast votes at election. It was said that states were denied the right, they would be denied representation. It was also said that if the states were denied the right to cast votes at election, the parity between the states and the union would be disturbed. All that argument is considered, and kindly turn to paragraph 29. Again, it was said by the interveners that Article 54 reflects the democratic patterns of participation by the states in the choice of the president, and if a state were denied such a right, it would be undemocratic. Recourse was taken to Article 368 to show that Articles 54 and 55 are mentioned in the proviso to Article 368. And if any amendment of Articles 54 and 55 is required, consent of the states is necessary. It therefore said by the intervener in Articles 54 and 55, read with 368, would be a key to the interpretation of Article 62, that no election of the president could be held without the representation of the elected members of the Legislative Assembly of the state, where the Assembly has been dissolved. These submissions on behalf of the intervener are without substance. Then we go to paragraph 47, the conclusion. Can you also make a note of paragraph 33? If as a result of dissolution of a legislative assembly of a state, there are no elected members of a legislative assembly of a state will not have been an elected member of the state legislative assembly to qualify for the electoral college. It may be said in the analogy of the observations in the Caracas Supra There are vacancies in the Electoral College by reason of the fact that there are no elected members of the Legislative Assembly of the state, where the Legislative Assembly is dissolved. That matter will not be a ground either for preventing the holding of the election on the expiry of the term of the President, or suggesting the election to fill the vacancy caused by the expiry of the term for the office of the President could be held only after the election Legislative Assembly of the state, where the Legislative Assembly is to be held. So for the proposition, and then kindly paragraph 47, the conclusion is drawn. Paragraph 47 is at page 57, running page 57 of the judgment.
Yes, yes, Mr. Attorney General, we've seen that.
Therefore, we are trying to find out if falling back on the proviso is an impediment. Therefore, the President is deprived of the authority under clause 3 to go either way. Will that not do violence to the text and the intent of Article 370? So one principle in law is very clear, that no text once enacted will efface itself out. We only know the principle of express or implied repeal. So there's nothing like, I have done my duty, therefore I exit the scene. Clause 3 still remains as an important part of reaching the exit stage. The only question is, how do you reach it? What is the more thorough way of reaching that exit stage? What consideration will weigh the President in exercising the power under clause 3? So one possibility is, maybe it's extreme, to say that because the Constituent Assembly is no longer exists, the proviso dissolves itself along with the Assembly. That's one way of looking at it. Suppose we don't want to go that route. Then the President could have said, I am free to exercise my power under clause 3 to bring to a close all of Article 370, subject to whatever other considerations the President may take into account. The other way is, should I try to follow a precedent set by the President earlier by recourse to Article 367 and recourse to Article 371D? So extending any provision of the Constitution with modification and find out if I can possibly take the assistance of any body who can fit in within the framework of the Constituent Assembly. So in 2 occasions, the President has done that earlier. I'll come to those details. So there are a large number of provisions in the Constitution, which Dhawan also tried to point out, non-legislative functions of the legislature. You pass a resolution, you pass recommendations. These are non-legislative functions. Recommendation power, a role assigned to the Constituent Assembly, was a non-legislative function. It is not a legislative function at all. Here's the reference. Yes. Video page. And then we have a key in Article 356, 1B, where after a presidential proclamation, the President can declare that the powers of the legislature. It doesn't say the legislative function. So he talks about a compendium of powers available to the legislature, and that the president takes over to hand over to the parliament. Therefore, the sequence of events which is contemplated in a situation like this, where there is a void,
So non-legislative.
there is an impossibility of complying with the proviso to clause 3. And how do I fill that void, if at all it's a void? I said the president could have said, without recourse to any other course of action, I could have myself taken decision on rendering Article 370 inoperative subject to modifications. But the president does not adopt that course. She wants to be guided by a process which will closely be approximating to the non-legislative functions of a constituent assembly. That is where the legislative assembly substitution comes in. And once it is the non-legislative power of the legislative assembly, under 356(1)(b), the parliament can certainly say, I take stock of what I can do. And the parliament recommends to the president, which then we see at CO 273. So therefore, there's a sequence in which president addresses having regard to the magnitude of the problem, the importance of the solution to be arrived at, and the difficulties in handling these momentous issues facing the nation and J&K for a long period. So all these imponderables enter into the decision-making process by the president. Therefore, if a particular process is sought to be the best process, in order that any legal objection could be taken against that, is not taken. You may still find a hole in that. That's a different matter. That's how the sequence of events have taken place. So I don't find, therefore, if the doctrine of impossibility stars one on the face, you are not paralyzed. So since Article 370, the author, sometimes I wonder poor Gopalasamy Iyengar, we keep talking about his statements in the Constituent Assembly. We have traveled far beyond what he thought was happening. Therefore, if we think that clause 3 of Article 370 was undergoing a natural death, I don't find any room for that to happen at all. So what happens today is, because of the age of the text, the long duration by which Article 370 has been used, rightly or wrongly, we have counsel for the petition saying we are reasonable authors of the text of Article 370. So on the one hand, the original author, the original intent, and its practice over a period of time, which can be given a certain understanding in construction. On the other side, we are the reasonable authors of what we'll say about Article 370. Well, two schools of thought there. One which says 2 and 3 will efface itself out. The other says the whole of Article 370 will go, because after 1957, it can't serve any purpose. So this conundrum of two reasonable authors entering into a construction as against the intent of Article 370 and its practice to be considered on an objective basis, having regard to the purpose which Article 370 was sought to be invoked at that point of time. So all that will enter into the construction of Article 370. So that's why I say the president is not precluded from taking stock of all this. It's not really writing on a clean slate now. I mean, one has to take stock of what has happened over a period of time. You may have so many choice of action. You may have called upon to comply with certain mandatory requirements under the Constitution. You may have taken the Article 3, the view of the legislature. Very important mandatory requirements in ordinary times. But when certain other compelling circumstances which confronted the nation for a long period, the parliament, the president. So therefore, all those variables which enter into taking a final view on Article 370 has been taken in this manner. That's why I started saying about Lincoln, I quote from an entirely different perspective. It's not about end justifying the means. It's about taking stock of a very complex situation. Do we have a mathematical formula to do it? Or do you only measure it by saying there are constitutional mandates? If you disobey them, you breach them, then you can't follow any portion as regards Article 370? Or look at the future of J&K. I do not know whether these questions can be answered on any normative mathematical position through a judicial scrutiny and then weighed on various fine golden scales. Very difficult. So when Keshavananda Bharati has told us now, look here, don't breach fundamental features of the Constitution. Now it's become an integral part of our understanding of the Constitution. Therefore, we are told to go forward, say how the salient features of the Constitution and its functioning and exercise do not permit any deviations. Fair enough. But you look at the entire Part 18 of the Constitution, 352 onwards. And 352 occupies a very important place in the constellation of Part 18. External aggression, internal disturbance. So how do we have a mathematical yardstick and a criteria to say, this is how you will do it in the context of external aggression. This is how you will do it in the context of internal disturbance. You will have some fair, broad standards where fundamental values are not breached. But if there is something which you have to negotiate, even with the breach of some fundamental values, what do you do? Is it a political question or is it a pure judicial question to be answered in the basis of textual reading of the Constitution? Well, that's what is confronting the court. But we're trying to assist the court in saying that you come as close as possible certain meanings which will advance the course of justice and understanding the scheme of Article 370. So this maxim, impotentia excusat legum, has been applied in large number of circumstances in the field of contracts, in the field of legislations, so on and so forth. I'll give a few illustrations later. Right? Then we take your lordships to go beyond this judgment. Take me to submission. P70. A few minutes. We have a mass of
What else? What more now, Mr. Attorney?
I may request Lordships to come to my written submissions and that's volume 4. Just want to place a few comments at this point of time.
What would be the PDF page?
Yeah. Volume 4. There's a separate volume.
Yes.
Internal submission,
What
separate
page?
volume.
You were
Yes,
read up to a
page,
point, so.
PDF page 26. Couple of paragraphs from the submissions. I just want to make a small
Page 26.
observation that in the context of what I was trying to communicate to the court, one looks at all those statements from Keshavananda onwards, Bommai in the 1977 resolution case. The justiciability of the decision-making process. President or no president does not make a difference. If the justiciability will enter in the decision-making process. They were all cases of dissolutions of assemblies. A very, very narrow question of a dissolution of an assembly. But here we went in a larger canvas. Lordship, please.
You're referring to the standstill agreement or something? So that is what page 26 is about.
Which is the para that you're referring to, Mr. Attorney?
Yes.
Because page 26, we have, the standstill agreement, as Justice Call said.
Your page 26. I think it should be page 27. It begins at page 27. Video page 27.
Idea of Article 370, its relevance and scope.
That's right. That's right.
Let's read through it. Let's see. Yes, we
Video
got it.
page 27. So before I try to convey this, that you try to invoke the jurisprudence of Bommai in a context like this, that could be a problem. As I said, there is a context of a resolution of an assembly. What factors go into it, whether they are relevant, objectively scrutinizable or not. But we are, as I said, in a larger canvas of taking a decision which has not only an importance for the purpose of looking at a part of the constitution which served a certain purpose over a period of time, but looking at the future. So in all those cases, you're looking at an event which had a limited impact at a given point of time. We are looking at events which will have a far-reaching importance forever in the future. Therefore, anything which is said in Bommai as conclusive in regard to judicial review, sovereignty, etc., I think may not be opposite. Let me not be taken to be understood that merely because there is too many complexities involved, the importance of the decision to be taken, and the impossibility dimension, etc., certain fundamental mandatory requirements of the Constitution can be slighted. I'm not proposing that at all. But we are trying to find out if, without slighting them, if there is a way that has been adopted, or if it's not been fundamentally breached, irreversibly breached. I'll come to that argument a little later. Therefore, the court will look at it very differently. So let me try to read a few paragraphs of my submissions here in 370. I have been trying to say this, that in paragraph 3, Article 370 envisaged a scheme of constitutional integration of the state of J&K with the Union of India, and thereby establish an interim system for the governance and administration of the state of J&K unit. A complete integration was achieved as was done in respect of other states. That's why much labor was taken by learned solicitors to told your lordships. Look at the long history of what happened in the rest of the country. We all went through, many of them went through the process of constitutional ideas, constituent assemblies, a draft constitution, then comes Bierendorf's committee on a model constitution. So all that has been gone through in the rest of the country. So it is nothing new which has happened here. Only thing is, having regard to the situation obtaining then, the external issues. The parliament thought, let us tide over it. How do you tide over it? We need a mechanism to tide over it. And we also probably inject into it a constitutional integration thought. That constitutional integration thought, as the three aspects of 370, as I told you lordships yesterday, that I have set out in paragraph in the running sequence under the same page 30, paragraph 9, the three dimensions of Article 370. So except the third dimension, namely termination, the other two dimensions have deep relevance to the constitution making process, constitutional integration process. So how will Parliament come and legislate before the Constituent Assembly takes a final call on what kind of a constitution we will have or a document we will have? So to enable Parliament to come in and legislate during that period, and once that is done, which has now become a permanent feature of the Constitution. So constitution making process was there in we have in Article 371 and 2 subclause B. So the other part is you extend the provisions of the Constitution. That's an equally important part of constitution making process. So once you extend the provisions of the Constitution, then what remains thereafter? So final constitutional understanding of what framework a Constituent Assembly will arrive at has to be aided and assisted by this process. Importantly, a fair element was drawn in consultation and concurrence. We're not in the point whether it's Sadri Riyaz as a governor, later prime minister, all those things are probably irrelevant. You're looking at the substance, not the form. If these are the three dimensions of Article 370, I would very respectfully say the termination of the role of Article 370. It could have happened any time. It could have happened soon after 1957. It could have happened even after when Article 35 was introduced and somebody could challenge is what is happening in Article 370. Now that it has happened at some point of time, and the termination has to be brought about in a particular way, which is the best and the most suitable way the president thought in the given circumstances. That's why I said taking stock to be an effective way of bringing it to a closure. I can't imagine anything out of thin air. I have to find out the best way available within the framework of the Constitution and the precedents available to the President, where Article 371D have been invoked, substitutions have been made. That's why I'm on pains to point out that when you talk of substitution of a Constituent Assembly by Legislative Assembly, we are looking at the non-legislative functions of the legislature as well as the Constituent Assembly. If the Constituent Assembly had recommended to the President before 1957, it would have done the same job. So if it could be done by any other equally competent body, now today first steps in the Legislative Assembly, and because there is a President rule, the Parliament steps in. To say that the Parliament is of a lesser paramount character than the Constituent Assembly in taking decisions for the nation's future. So, therefore, there is a weighing or a balancing may have to be a very, very difficult job. But my submission is, so the termination of Article 370 must occur at some time, notwithstanding whatever has happened over a period. And if the termination can occur in more than one way, whichever is the way which will advance the larger interests. That's why you look at the firmament of Chapter 18, Part 18 of the Constitution. I yesterday read out few parts of Chandrachud judgment to show that the president, the exercise of power of the president is legislative and not executive. The governor's powers under the 5th schedule, powers under the 6th schedule to extend a parliamentary law to the 5th schedule area has been said to be a legislative exercise. So modification has been considered with several judgments to say it's a very wide amplitude. It's as good as sitting in judgment over the parliamentary legislation or the Constitution. President is given that power to extend the constitutional provision with modifications, with that supreme authority given to the President. Yesterday I pointed out at page, PDF page 33, that's part of Chevrolet's judgment. The middle of that paragraph, where it says, Your Lordships have that page of my. The one sentence, application conforms with it. That's right. That's right. I just want to. Then let me take your Lordships to few aspects of the recommendation. It's only to throw some light on that. Paragraph 12 at page 36. You can pick up any dictionary or any precedent on this question of nature of recommendation. There are a large number of provisions in the Constitution of India which uses the word expression recommendation. The context would be important. Sometimes it's a recommendation which can't be simply ignored or disregarded. Sometimes it can be binding. But by and large, the recommendation concept is to advise, to commend for action. All that few illustrations I have set out here in paragraph 12, I don't trouble your Lordships with reading. I just only conclude this part of the argument by inviting lots of attention to paragraph 18 of the submission, that page, internal page 38. Either the legislature of the state nor any resident of the state has any independent right in the continued retention of Article 370. In other words, beyond the constitutional integration process visualized to be completed, there was no other purpose of Article 370. As such, no person could claim the right of permanent retention of Article 370 as a permanent integration process. And the concluding observations are in paragraph 21, begins at page 39 and ends at page 40. And the last few sentences here, running to this page number 40 of the PDF. And that's right.
Let's read your conclusion, Mr. Atkinson, how you sort of sum it up.
Therefore, we are told that Article 370, by reason of its exercise over a period of time, is now open to several interpretations. And there's only one solitary interpretation, that it is to aid the constitutional integration process. Whatever has happened even thereafter will have to be seen in the light of that. If anything has, by way of deviation, occurred, well, it is open to correction by the president. So that's precisely what's happened now. The president says, I started saying, the president is not precluded from taking stock. The taking stock is inherent in Article 370. So if there is anything intrinsically which forbids the president to take stock of Article 370 and its exercise over a period of time, then one can understand it. But I don't think anything is available there. So therefore, I think it will open to the president to take stock of all the exercise undertaken under Article 370 and take into account the larger considerations which loom large before the nation, particularly the state of Indian case.
Yes, Mr. Anything else, Mr. Attorney?
Your Worship. So we are confronted with just shifted the page. This part of it. Page. I'm sorry, navigating the system.
We are also navigating the time constraints, Mr. Attorney, now. So I think we can wrap up now, Mr. Attorney. If something remains, you can tell us after lunch if there's some thought which escaped your mind or something.
I would have done it very briefly now.
Yes.
Right. I had a shared with the court. There's some document I wanted to share with the court. I think it's missed getting into the court system.
Mr. Attorney, why don't we do this? We'll call upon the next counsel. You can come back to us after lunch if you're junior and you can find it at lunch. We'll give you 2 minutes. There's no difficulty. So if there's some important thought that you have missed, we'll certainly not stand on the formality of concluded the argument. We'll let you again. So if there's something which remains, you can tell us in a minute after lunch, Mr. Attorney General.
Very well.
Thank you, Mr. Attorney. Mr. Sarve will be arguing
Yes.
after this. Yes,
I
Mr.
have
Sarve.
Short submission.
to make, before I come back on that. In my I thought we wanted to share a two-page note with your lordship, but I think it didn't get into the system. Let me do it.
There's some thought which remains. You can come back after lunch. No difficulty.
Very
Thank you, Mr.
Very
Attorney.
well.
Thank you. Yes, Mr. Sarve.
Yes.
I have a few okay, then I'll come back after.
Yes, sir.
after lunch.
There's something, a point here or there which has been missed out. You can
Yes,
tell us.
I'll
We'll add
continue
it.
that
We'll
up.
add it.
Because there are a few observations I want to make on certain aspects. So can I continue thereafter? Yes.
Yes. Yes, Mr. Sarve.
Yes. My lord, I don't want, your lordship has heard this matter on both sides at considerable length. And the solicitor has, in great detail and with his customary meticulousness, ticked all the boxes and covered all the points from our point of view.
Appearing for in this matter, for the sake of the record, we must make a
Yes,
note of that.
I'm appearing on behalf of the applicant in IA 9573 of 2020 in petition 1099 of 2019. I have, my lord, for your lordship's convenience, made a 3-page roadmap of what I'm going to submit, if your lordships permit me to hand it over, so that it will be easier just instead of your lordship noting down.
Yes, Mr. Sarve.
Yes.
Has it been given to the court master already?
I believe so, my lord. Mr. Agarwal from... It has been sent, I believe, my lord.
अभी भेजने हैं यार। He'll just display it for everybody because that way the other side also knows what your arguments
Yes,
are.
yes.
So therefore we take it as just an aid memo, nothing more.
It's like a skeleton of submission.
All right.
It just sets out the points which I'm going to address, not what I'm going to say.
Just give us a moment, it will be uploaded so that
Yeah,
that way
not sure.
your learned friends on the other side also simultaneously
course.
can see what we have. Shankar Narayan, you can tell Mr. Dhawan and Mr. Jha. They'll get it on the main screen as well. But I'm sure the main screen will also have it for. Hey, George.
No, without interrupting my learned friend, I just want to, there's some part which is missing in our, I try to upload it to the, I can share with the lordships. Right.
Yes, Mr. Sare?
Yes. But I'm only to, as my note said, I'm only supplementing some of the submissions which have been made already. And I've just picked up the issue. One is, my lord, construction of the proviso to sub-article 3 of 370. The attorney has addressed your lordship at length. Only a few points to add to what he has said. The width of power under Article 370, because that has been the subject matter of some discussion. The nature of the power exercised by President under various sub-articles of Article 370, I don't think, I mean, there was a suggestion made that this might be executive in nature. The absence of a challenge on administrative law principle of abuse of power, it's necessary to get a few concepts in their right perspective. The exclusion of judicial review beyond the question of competence, questions that are political in nature. And the use of power under 356 to make changes that may be irreversible. And finally, the violation of basic structure. Very short submission in each of these headings. The first point, my lord, relates to the construction of the proviso. Your lordship, I've heard detailed submissions by the solicitor and by the attorney. And my lord, I just want to put it in a frame. So normally, these are the three aspects which one would look at: the textual, the contextual, and the historical. We have, my lord, and the solicitor read it out to your lordship. The author of the provision and the list of dates given by the solicitor sets out in detail the confabulations, including differences of opinion on whether there should at all be a special treatment of Kashmir. Then, my lord, Gopal Swami Iyengar's draft, its brief discussion, and its adoption by the Constituent Assembly. And one thing was clear: this was an element accommodating certain compromises, political compromises within the constitutional framework. Your lordship has read all of that. I'm not going to repeat reading any of that. But that has been sufficiently put across. And it now stands as it does. And its words have to be given their plain meaning. So, my lord, the first thing your lordship would do in my respectful submission is the textual bit. Now, in the textual bit, what is of great significance in this point has been put. If the idea was that the president could act only to give effect to a recommendation of the Constituent Assembly, then that would have been made the precondition for exercise of power. Perhaps the article would have said, if a recommendation is received from the Constituent Assembly, then the president may. And your lordship, in fact, in the course of the hearing, my lord, the Chief Justice gave the example of certain other articles where it says, if a reference is made or if something is done, then. But that's not the frame in which this was drawn up. One of the articles, my lord, of that kind is 249. Courts are very well familiar with that. It starts by saying, if the Council of States has declared by resolution, then it shall be lawful to make laws. So that is a precondition for the exercise of power.
But Mr. Salve,
Yes.
does the proviso to Article 370 bracket 3 does not bring about the same result
Yes.
by the use of the expression shall be necessary?
Yes. So, my lord, shall be necessary here must then be subject to the principle that if there is a constituent assembly, then it's first of all, the word is recommendation, not concurrence. And secondly, that becomes necessary because if there is a constituent assembly, then you cannot act in vacuo. That was, in my respectful submission, the textually, because my lord, we must first of all discern legislative intent out of language. And from the language, when the Constitution knows, or the drafting of the Constitution, the authors of the Constitution knew that there were certain models in which it says, if something is done, then you may exercise a power. Is the president to act, my lord, only to give effect to the desire of the Constituent Assembly, or is he to receive a recommendation from the Constituent Assembly? And obviously, the compromise was he must receive a recommendation from the Constituent Assembly, which obviously means if there is one, he must. Secondly, my lord, this very article, and we have all this is textual. This very article uses two separate expressions. B2 uses the word concurrence. I mean, it's a point which has been already made. And the proviso uses recommendation. Now, if, my lord, one had put concurrence here, the argument would still remain, but it would have been a much stronger place for the Constituent Assembly. So while, my lord, distribution of the fields of legislation in subarticle B of, in clause B of subarticle 1 was put as concurrence of the government of the state. At the same time, subarticle 3 used the word recommendation. It's not an amendment, it's not this. So, my lord, one must assume, and this was a article which had internal dissensions and differences, and it was very carefully crafted between within the committee and within the assembly. There were differing points of view. So, my lord, we must give meaning to every word of this article. So the difference between concurrence and recommendation and its framing as a proviso. At two places, again, subarticle 2 says, if the concurrence. So, my lord, this is a very conscious departure from the concurrence, recommendation, consultation, recommendation, concurrence. One would perhaps say the difference is, if you fail to consult, it is not fatal. If you fail to obtain a recommendation, if a recommendation is necessary, it is of more serious consequence. Would it be fatal? I don't know. Concurrence, obviously, because concurrence, then your power gets hedged in. And this is all textual.
So, Mr. Salve, there is one countervailing consideration
Yes,
which we
yes.
possibly may have to bear in mind,
Yes.
that where a change in the distribution of legislative power was envisaged,
Yes.
the provisions spoke of concurrence,
Yes.
except in the area which was covered by the instrument of accession.
Yes.
The exercise of the power under the proviso to clause 3 brings about a complete abrogation of status.
Correct.
Abrogation of 370.
Yes.
in which case all the limitations which are even introduced by the earlier provisions of clause of Article 370 are lifted.
Yes.
Including the concurrence on the distribution of legislative power,
Yes.
consultation.
Yes.
Now, could it have been the intent that you require the concurrence for altering the distribution of legislative power or for altering any other provision of the Constitution, but for abrogating the article itself, nothing more than a mere recommendation is required?
Which, my lord, drops me, I'm deeply obliged, my lord, which brings me to the second, the contextual.
Power under the proviso is exercised,
Yes.
then there is no limitation at all.
Absolutely. And that, my lord, brings me to B, the contextual. And in fact, that was the direct intent. And your lordship will see it from another point of view. There's another point of view. Till the arrangement is in place, unlike other states, where the Constitution sets out legislative powers in the 7th schedule in absolute terms. And you need a very elaborate mechanism to tinker with those 7th schedule. It has to be with 50% states voting, etc. Your lordship knows the difference. Here, there was a political agreement and the whole circumstances, including, as Mr. Anger spells out, the specter of the United Nations, which today is, of course, irrelevant, but at that time was very relevant. The problems in the state. So there was a agreement which is embodied in B, which has concurrence. But if this led to a situation which ultimately prevented the purpose of 370, the purpose of 370 was not to create a permanent divide in the Constitution. Lots of material has been shown to your lordship on this. It was a phased integration. I'm going to deal, Dr. Dhawan has raised a very interesting point of asymmetric federalism, whether that became part of the basic structure. I'm going to deal it separately. But the historical material available to a court, and we have, unlike certain other courts, we have always looked at historical material, especially for articles like this. There was a safety valve in sub-article 3 that if the political compromise in sub-article 1 fails to achieve the purpose, at any time it might become necessary to pull the plug. And sub-article 3 is that plug. Now, if one looks at it that way, the whole thing falls in place. The framers of the Constitution kept with the President the power to do away with this special arrangement.
Yes.
And history bears testimony to the foresight and wisdom of those, despite the criticism at that time and the political debate which must, in a democracy, you must always have the noise of a democracy, Mr. Bhutto used to say. The noise of the democracy is the most essential element of a democracy. So this has been the subject of debate. But your lordship has seen the entire history of how phase by phase this has been narrowed down. The divide has been narrowed. More and more subjects were added. More and more alignment was brought about. Because the historical perspective of 370 is very important. The troubled relations. While there's always was a hope that the relations with the neighboring country would be on good terms. The history of Kashmir did give rise to apprehensions. And the Lordship has seen all the material. So, border state, with all its sensitivities, is what compelled finally the Constituent Assembly to agree to the special arrangement. But with their wisdom, they said, while you phase it in, you have the power to pull the plug. And this is what I call the contextual interpretation. So the plain language, pure text, and the context.
What is the context, Mr. Salve? How is it distinct from the historical background or the plain text?
The context is that this read by itself, forget the history, this read by itself shows that in sub-article 1, there is a divide in the legislative list base aligned to not the constitutional general 7th schedule, but to an instrument of accession. Broadly, the idea was aligned with the instrument of accession. That's how the powers will be shared. And a partial application of the Constitution of India, not in its entirety, but such other provisions. That's the D. That's the context. With a safety valve in 3. And my lord, the history of this provision also tells us it may be difficult to find a logic in each of these because these were a political compromise. Why was the Constituent Assembly put there? That was a compromise. A lot of things are done to assuage ruffled feathers. There were 2 approaches. One was the jackboot, saying, doesn't matter, things will settle down. Don't agree to anything special for Kashmir. The other was the other extreme, saying, if the legitimacy of the accession is being questioned and there is a popular uprising, accommodate that. This was the compromise. So, my lord, one cannot search for too much logic. This was the compromise form. And we must therefore, my lord, the safest thing for a court, in my very respectful submission, as a matter of constitutional interpretation of such provisions. And such provisions are essentially political, and I don't mean political in its pejorative sense. I mean it political as in its constitutional sense. The court has always said you must give it the widest possible meaning. In fact, my lord, I'll give your lordship that passage. Justice Pandian, I think Justice Pandian, in his majority opinion, where he upheld the abolition of the privy purse, where your lordships upheld the abolition of the privy purse, he says that our constitution was meant to be flexible in these areas. I'll give your lordship the exact passage. The fact that the ground realities would change in Jammu and Kashmir and 370 would accommodate was, my lord, first recognized by your lordship in the Makbul Damno case, which has been cited. The challenge brought where Mr. Garg argued that without the Sadr Riyasat, you could not have the preventive detention law. And your lordship said state means state as exists from time to time. That is, my lord, already there. I'll give your lordship the passage 72-1 Supreme Court cases 536.
You have given us para
It's
28
there, my lord. It's volume 1 CLC
and
PDF
you said para
36.
28 there.
Para 28. So this was already one example of how this evolved. And that, my lord, backs in with a principle of construction. Your lord, the attorney just cited the presidential reference case, which says, well, if there is a requirement, then if there is a constituent assembly, you must get the recommendation. But if there is no constituent assembly, are you denuded of the power? And the presidential reference, my lord, the attorney just gave your lordships a moment ago, the judgment based on a passage on impossibility. And your lordship cited with approval Craze on Legislation, the 6th edition, in the presidential reference. The attorney just gave it now. The attorney just cited it. I have, my lord, for your lordship's assistance, given the 9th edition of Craze. I believe it's attached to my submissions. There's some slight interesting change in the text. I believe it is at PDF page 37.
Mr. Salve, which is your compilation of it?
My lord, it's. I believe it has been given along with my note.
Is it along with the note itself?
Yes. This is, my lord, from the 9th edition of Craze. It's called Disregarding the Impossible. Para 8.2.9. It is appended to the note.
What page did you say, Mr. Zari?
Page 37 PDF.
Yes. Disregarding the impossible.
Yes. Yes. There's a slight difference in text from what your lordships approved, and in fact, it's even more instructive. It says one of the ancient maxims of common law is lex non causa ad impossibilia. As Broom's legal maxim puts it, the maxim, or as it is expressed, impotentia excusat legem, must be understood in the qualified sense that impotentia excuses, where there is a necessary or invincible disability to perform the mandatory part of law or forbear. It is akin to the maxim of the Roman law, nemo tenetur ad impossibilia, which, derived from common sense and natural equity, has been adopted and applied by the law of England under various and dissimilar circumstances. The result of the application of the maxim, which remains potent, is that the draftsman need not expressly excuse that compliance, which is obviously impossible. So, for example, if requiring a particular communication to take the prescribed form, the draftsman need not generally state that the requirement can be lawfully ignored where no form has been prescribed for that purpose. There may be occasions, however, where the sense of the legislation makes it arguable that the primary provisions are not to operate at all until certain mechanisms have been put to place by subordinate legislation. If the draftsman thinks it is necessary to avoid a suggestion of that kind, he will generally qualify a reference to the prescription by, if any, of that kind. So, my lord, the principle is very interesting. In fact, we have used it in a different branch, my lord. In service law, for example, we've used it all the time. it says your promotion will be as per rules. Now, if no rules are framed, doesn't mean you won't get a promotion. Then you follow whatever is the general principle. But if there are rules, they must be strictly followed. Oh, my lord, this was the argument in this court. Of course, I went through the judgment. It didn't get to that point of deciding it. The old section 80J, rule 19(1)J, and the argument was, for example, if it says deduction of capital employed, if there are rules, you follow them. If there are no rules, doesn't mean the exemption fails. But there are other provisions which says you will get such other deductions as rules may provide. And that you can't operate unless there are rules. So we have had one of these two formats. And that is why we come back to why did the framers of the Constitution not say that if the President receives a recommendation from the Constituent Assembly, then he may. And instead say the President may abrogate this article, provided if he gets a recommendation from the Constituent Assembly. Which there is one, you must get the recommendation, otherwise. Now, my lord, this was also made.
Just 1 minute.
I'm sorry.
Mr. Salve? I think perhaps we'll just wait for a second, Mr. Yes, Mr. Salve. Mr. Salve? Voice is perhaps, for a moment he was...
No, my lord.
Yes, Mr. Salve.
Yes. Can your lordship hear me, my lord?
Yes, we can hear you now.
Yes. Finally, my lord, look at one important nuance of this article.
Yes.
In subclause D of clause B, such of the other provisions of this constitution shall apply in relation to that state, subject to such exceptions and modifications as the present by order specifies. So, power to the president to apply or disapply provisions of the constitution or apply them with modifications. And this does not require unlike B1, that is the spread in the list, the concurrence is not called for.
Let's look at it now, Mr. Salve. Let's see that again. I don't.
Yes. If your lordship sees 372(1)(b), 1 is the spread, my lord, of the list. Small subclause is 1 and 2 is this.
Corresponding to the IOA.
Yes.
That requires consultation.
That requires concurrence. That comes in through the first proviso.
B.
Proviso, no such order which relates to.
Requires concurrence.
Yeah, B1 requires concurrence, consultation.
No, consultation.
Correct, my lord? And no such order which relates to matter other than those referred to shall be in the concurrence of the court. So this was built in. This dichotomy was built in there itself. Now, two things, my lord, your lordship will note. Applying or disapplying provisions of the constitution.
No, Mr. Salve, I could not get this argument.
Yeah, yes. May I just restate the point, ma'am? Clause D relates to not 370, but other provisions of the constitution.
Absolutely.
And they can be applied, disapplied, or with such modifications as the president considers appropriate. And that is with the concurrence of that government.
Yes.
Correct, madam? And sub-article 2 says, is the concurrence referred to in paragraph 2 of B of clause 1, such other matters, or in the second proviso, that is, my lord, would be D, be given before the Constituent Assembly for framing of the Constitution, it will be placed before the Assembly for such decision as it may take thereon. So this was meant to operate much beyond the Constituent Assembly also, because that concurrence would continue forever. There would always be a state government. But state government, what that state government is another matter. There would always be a state government. But disapplying 370 was carved out and put in 3. Now that can't be a provision limited in time to the existence of the Constituent Assembly. And that is what explains perhaps why the recommendation rather than concurrence.
Mr. Salve, your voice was cracking just a little bit, when you were making this, the last part of your argument.
Yes.
Maybe.
I'll repeat it, Marat.
Yeah, if you could.
Disapplying 370 itself comes under sub-article 3.
Right.
And that is why perhaps the framers of the Constitution scaled it down to recommendation instead of concurrence. And that to put it in a proviso that when there is a Constituent Assembly, during the life of the Constituent Assembly, if you decide to modify 370 or disapply 370, because the whole purpose of the Constituent Assembly was to work to try and find this area of accommodating both.
That's
So if
fair enough. Mr. Salve, we got your point.
Yeah,
That
that's
after all, this is a proviso.
Yes.
Two, it uses the word recommendation and it does
Yes.
say if there is a recommendation. We got that
Yes.
point. We got that line of argument.
I was just closing it by saying,
You're making just a little while ago
yes,
was that you began by saying that B1
yes,
requires consultation. Matters in the list other than those covered by the IOA requires concurrence. That is B2. Then we went to D.
yes,
D says, subject to such exceptions and modifications as the President may order by order specify.
yes,
There also there is a bifurcation.
yes,
Those matters which refer to the instrument of accession require consultation. Other matters other than those governed by the instrument of accession require concurrence.
correct. Now, the point which I was making, perhaps
That's
that
the
got
point which
lost.
we wanted you to just come back
Yes.
to again. Yes.
So again, my lord, why this subtlety of instrument of accession being consultation and other than instrument of accession being concurrence, the significance should not be missed. Where it comes to instruments of accession and terms of accession, the last word is with the union.
No, where do you say that? How do you say that?
Because, my lord, instrument of accession requires consultation, not concurrence. The first proviso.
Subjects are so important. Convenience.
Why this dichotomy in the first and second proviso, my lord? Your lordship would have to reflect over. And that also, my lord, feeds into my point, therefore, that where it comes to disapplying the 370 completely, because the whole idea of 370 was accommodating the political compromise in the accession.
You know, Mr. Salve,
Yes.
clause B of 370, 371B
Yes.
does not relate to the power to make adaptations, modifications, or exceptions at all.
Yes.
What 371B says is that of all the items in the three lists, the President, the power of Parliament to make laws would be limited by specific matters.
Yes.
So you take the matters in the list as they are, and then you define what would be the domain of Parliament to make the law. There's no power to make exceptions or modifications in clause B at all.
No, not at all.
Bifurcates. You correctly said that there was a bifurcation. Matters which are referable to the instrument of accession are those on which you only require consultation, because
Yes.
these matters clearly specified in the IOA: defense,
Correct.
foreign affairs, communication. Therefore, when Parliament specified the matters on which it would make laws, if those matters were referred to in the IOA, only consultation of the state government was required,
Yes.
because they were specified in black and white in the IOA.
Correct. But
Matters which were not specified in the IOA but are governed by the three lists, concurrence is required.
and my lord,
Now, when it comes to
yes.
D, D is not just specification of matters. D is making exceptions or modifications.
That's right.
There again, they had a dichotomy. You can make exceptions or modifications, but if it relates to matters in the IOA,
Consultation.
only consultation. So you are really right that insofar as D is concerned, in regard to matters which are specified in the IOA, only consultation is required.
And my lord, one cannot miss the significance, what I wanted to add, of the overlay of the principle of international law, which is engrafted in 363. That these are matters primarily for the sovereign. Instruments of accession and their interpretation has always been a matter for the sovereign. And here the accession being complete, irrevocable and irreversible. That is clear. 1 and 3, Article 1 and 3. Where it touched the instrument of accession, the President had the last word. And that philosophy is reflected in sub-article. That if you want to completely disapply this political arrangement, if there is a Constituent Assembly, consult them, otherwise you can do it. And there also recommendation.
In other words, Mr. Salve, what you're trying to drive at is that clause 3 of Article 370
Yes.
is absolutely on the same is on the same
Philosophy.
trend, or is the same platform
Yes.
as clause B1 and the first proviso to D. You are trying to equate the power and the substantive part of clause 3.
The underpinning is the same, my lord.
Power
The
under
underpinning is the same.
the first proviso to D and B1.
Yes. And because the underpinning is, this is where we accommodated, or this is where the powers that be, when framing the Constitution, accommodated the political compromise in Kashmir. And unsurprisingly, they reserved the power in the President instead of driving one to Article 368. They reserved the power in the President to disapply this entire. It's a very unusual provision, my lord. There is no other equivalent. The executive, President is executive government, where the executive government can disapply a provision of the Constitution.
The only internal problem with that argument, Mr. Salve, we'll reflect on
Yes.
it during the research in the
Yes.
next hour,
Yes.
that where the power to do something lesser in terms of constitutional impact is hedged in with restrictions, namely the power to make exceptions and modifications, can we subsume that the power to have something greater, which has
Yes.
greater constitutional impact, namely the abrogation itself, will be bereft of all limitations?
My lord, to which my respectful response is, there is a compromise. I keep in my control, because the accession is complete. So what are the understanding? It's a part of India. 1 and 3 apply. It's an Indian state. But I have a political compromise in which sub-article 1 has how it will operate. That's the compromise. But sub-article 3 is to put the compromise to an end. And I reserve that power.
Mrs. Salve, we are almost at the anvil of lunch. Just
Yes.
one, maybe one of the juniors can do it here in the court as well.
Yes.
Found which were those matters governed by B1 and which were the matters governed by B2. B1 basically covered the 3 subjects.
Yes.
Now, which were the matters in the IOA to which the first proviso to D applies?
We'll not try and respond to that at 2 p.m.
So we'll,
I see that. I see that.
that will give us some insight on what was the intent.
Yes. I'm deeply obliged. We'll do that.
So many articles that deal with defense, which are covered by the instrument of accession. That list is given.
I had in my list of dates, Lordships would recall the sub-article A1 says that the President would demarcate which entries fall within those 3 areas. So there was a specific order passed, possibly the first order.
48 or 54.
Yes, my lord, which 50, my lord,
50.
What,
which
54
because
then?
communication would have telecommunication, postal communication, etc., etc. So three
So
entry.
which were the other articles?
No, we'll respond to that at 2 minutes.
Because the first proviso to D for Delhi, deals with other articles, not the specification of matters in the list. Not D1, the first proviso to clause D deals with other matters which are governed by the instrument of accession, where again consultation only is required. We're just sort of understanding Mr. Salve's
Communications is also in the list. That is also not other articles.
No, I don't think Mr. Sibal has understood. My lord, I followed your lordship's
Also in the
question.
list,
I'll respond to it too.
We'll also try.
That may have some bearing, Mr. Salve.
Yes,
on
yes,
how
of
we
course,
arrived
of course.
at our argument on clause 3. That's why I
Yes,
asked.
my lord. Yes, I'll do it at 2. I'll do it at
A
2.
very interesting point. We'll also leave it here.
Yes, yes.
The list is all there. Which one is also in the list?
Stay. Stay.
Yes, Mr. Salve.
Yes, my lord. In fact, I'm grateful to my lord, the Chief Justice, for the steer. If your lordship sees the instrument of accession,
Yes.
and this is in document 1, volume 1, sorry, page 9. Your lordships have it?
Yes. Just one second.
Yes. My lord, Justice Suryakant has it.
Yes.
If your lordship sees, it's very interesting.
Page 1. Sorry, page 1.
Clause 1 is the accession.
Yes.
He says, I hereby declare I accede to the dominion with the intent that the Governor General of India shall, by virtue of this, my instrument of accession, but subject to the terms and for the purpose of dominion, exercise such functions as may be vested by them in the Government of India Act as in the Dominion of India on the 15th day of August. I hereby assume the obligation of ensuring that due effect is given to the provisions, etc. Now look at 3, man. I accept the matters specified in the schedule as the matters with respect to which the Dominion legislature may make law for this state.
So this is B1.
Yes.
This corresponds to clause B1.
Yes, my lord. And this was in a schedule which I'll show your lordships in a moment. I hereby declare that I accede to the Dominion of India on the assurance that if an agreement is made between the Governor General and the ruler of the state whereby any functions in relation to the administration of this state of any law of the Dominion legislature shall be exercised by the ruler of the state, then such agreement shall be construed and have effect accordingly. Now, my lord, comes the most important thing. In 6 says nothing in the instrument will impart dominion to make any law authorizing compulsory acquisition. Now, this is interesting. This is a carve out from the legislative list principle. But I hereby undertake that should the dominion apply, etc. Now, my lord, 7 is important. Nothing in the instrument shall be deemed to commit in any way to the acceptance of any future constitution or fetter my discretion. And nothing in the instrument affects the continuance of my sovereignty and over the state, save as provided under the instrument. Now, this was the instrument of accession, but the Constitution finally, if the lordship now matches this with 3.7, and I'm sorry, my lord, for completeness, the schedule your lordship will find in volume 4, page 176.
So basically defense, external affairs and communications.
Correct. Now, my lord, what happened? But what the spread in 370 corresponds to is very important. 370 starts by saying the Part B provision will not apply. 238 will not.
Right.
Then it says the power of Parliament to make laws shall be limited to those matters in the Union and the concurrent list which in the consultation with the government of the state are declared by the President to correspond to matters specified in the instrument of accession. So this was on the issue of the legislative lists and that schedule. Matching them with our 7th schedule, and the President would decide how the 7th schedule is to be divided. And here it's only consultation consistent with the philosophy that accession and instruments of accession, these are what are in international law called political documents, not political in the political sense, political documents.
I think, Mr. Sarve, it's very clear now. If the President wanted to make any exceptions or modifications
Yes,
in respect of defense, communication, or external affairs, then only consultation was required.
correct. Now,
That is
my lord,
of the first proviso to clause D.
correct. Now, my lord, applying other provisions of the Constitution, and my lord, I don't have to give your lordships a catalogue of which are the other provisions. I mean, there are so many important provisions of the Constitution. They would be phased in and applied under D.
Right.
And for that, they said concurrence.
They would require concurrence.
They would require
Yes.
concurrence.
They referred to either defense,
Correct.
the
My lord, the
defense,
legislative
external
lists,
affairs or communications.
broadly, let us say the legislative lists are put to one side because that is really power to make laws.
Yes.
But my lord, institutions, your lordship's jurisdiction under 32, for example.
The Constitution also, yes.
Your lordship's jurisdiction under 32. Should it extend or should it not extend to Jammu and Kashmir? These are, and what about public service commissions? What about election commissions? So on and so forth. So my lord, all those were provisions to be applied if necessary with adaptation. Now, my lord, what is important? And I come back therefore to my point. This, how does this align with a complete accession? Article 3 is the answer. That this is an arrangement for the phased introduction of the Constitution, keeping or reserving unto the President the power to disapply this article. Now, obviously, for that, there cannot be concurrence. So it makes sense. Recommendation if there is a Constituent Assembly, otherwise, the action of the President. This was the arrangement, this was the compromise. And my lord, this compromise was not just with the state of Jammu and Kashmir, the solicitor has placed before your lordships the sharp differences of view even in the Congress Working Committee. They rejected this plan. First time when Shri Gopal Ayangar presented it. Sardar Patel's letter is cited in the solicitor's list of dates. He said, sorry, I don't accept these. So there were, this was a very matter with more than one point of view and competing points of view. So this was the compromise formula, which is incorporated here in the Constitution. This was the workable arrangement. This is all right. Ultimately, we will decide and we will keep to ourselves the power to disapply this article. But if this works phase by phase, introduction of the Constitution, why not? And it did work to a large extent. So, my lord, that principle, which my lord the Chief Justice was pleased to put to me, about lesser power and larger power, would it not require greater safeguard? That would not occur. That's what I call the contextual argument. I'm not finished with this, and I have eye on the clock, my lord. If there's anything more, I can assist your lordship on this point. Otherwise, let me move to my next point.
You can move. I think we can move to your next point, Mr. Salve.
Yes, yes. Second point is, my lord, there has been some arguments about even if 370 applies, because no radical change. And Delhi laws was citing. Now, my lord, some cleaning up, because some principles need to be clearly stated. The Birla cotton mills in Reed Delhi laws, the power to extend laws, you cannot make a radical change. But that can have no application here. That principle can have no application here. Because your lordship has seen those cases. Your lordships read down the power to extend and apply laws under Article 14. The argument was excessive delegation. You have conferred upon the executive the power to change a law made by Parliament and its application. And that is why your lordship said we read it down. That the philosophy, the basic policy of the law cannot be changed, radical changes cannot be made. My lord, 370 is a part of the Constitution itself. There is no question of excessive delegation. This is a power conferred on the president. And that is why my lord Lakhanpal rejects this approach. But I was giving your lordships an answer on first principles.
Yes.
The power, my lord, under 370 is plenary in nature. And this is a power conferred by the Constitution. A plenary power is not subject to the principle of, or is not amenable to a challenge of excessive delegation because the Constitution has made this delegation. Where Parliament makes a law which is subject to Article 13, or where the state legislature makes a law which is subject to Article 13, then Article 14 challenge can be brought saying this is excessive delegation. And all the Delhi laws, in Delhi laws downwards cases, all dealt with excessive delegation. In statutory provisions on the anvil of Article 14, it is completely irrelevant to 370. Your lordship has already said this in Puranmal, but I wanted to just put it on first principles.
Yes.
The second point is that the power exercise is legislative in character. I don't think I need to belabor that point very hard. Applying provisions and disapplying provisions, modifying provisions of a law is legislative in character. I don't think I need to cite authority for that matter. To suggest that this is an executive power is like saying ordinance making is executive power. And it is done by orders, Malad. I'll just give you a lordship a citation. The Meghalaya case with Schedule 5, for example, of the Constitution. 1972, one Supreme Court case is 148, just for reference. where your lordships have said that, because there also the president can by order say this and by order say that. You're not saying. So this is now what follows from a plenary power and a power which is legislative in character. It has a direct bearing on the next issue of the extent of judicial review, of the exercise of that power. Because that logically takes me to my next point, that the Ajit Mills principle, as Justice Krishna has explained in Ajit Mills. In the context of a law made by Parliament, if you say this is abuse of power or collective legislation, it's an argument of competence, not of motive. That is not the Ajit Mills principle. Your Lordship knows when the first law was made, saying if you've collected illegal sales tax, which is not chargeable, if you've collected, you pay. The argument was this is colorable legislation because you're taking away. And Justice Krishna's answer, I'll just give the page and para numbers, 77 4 SCC, page 98. This is attached to my note.
Page?
This is attached to my note starting from page 6. Page 4, sorry. And the relevant paras.
But Mr. Salve, even if it is a legislative power,
Yes.
as you say it is, and probably it is, it's amenable to judicial review on the ground of Article 14. A legislative power cannot be challenged on the ground of malefides. For instance, you cannot say that Parliament did something because of a malafide intent, because you don't attribute malefides to a collective body of individuals. That's the reason for
That's correct. More than that.
Nagaraj, when they reduced the age of retirement, our court said you can't challenge the reduction in the age of retirement on the grounds that Parliament was acting malafide, because it's a collective body. Malafide is something which you attribute to an individual.
More than that, my lord, your lordships have always said, where it comes to colorable device, supplementary, and all these, as it is not explained in this judgment,
actually they started that.
It is really a competence argument.
Colorable exercise of power in Tulloch, our court said, it really means that though
competence.
You are purporting to exercise power under one entry, you've actually transgressed into another entry. So it's really a question of absence of power, legislative.
It's a competence argument.
It's a competence argument.
Yes. It's not the Wednesbury unreasonableness.
Yeah. But equally, Article 14 would be attractive.
But 14
meet the test of Article 14.
But 14 can have no application to an Article 370 sub-Article 3 situation. Of course, legislative power you can, if you make a rule which is plainly discriminatory, you can strike it down on violating 14. Of course. Because if Article 13 applies, the whole panoply of fundamental rights apply.
But therefore, assuming that this is a legislative power, it is not immune to challenge on the ground of violation of fundamental rights.
Correct. Fundamental rights, whether a 370 sub-Article 3 disapplying Article 370 is at all amenable to fundamental rights, question mark. I'll address your lordship for a minute on that. Because this is a relationship between the union and a unit of that union. We are now units of that union.
They may be parts of that relationship which create rights in favor of individual citizens.
But if it affects an individual,
a classical part of that, the provision of the on the right of residence. An individual, for instance, can say that I and people belong to my class have the exclusive right of residence in this state. By bringing in others, you are affecting my right under Article 14. Whether there is substance or not is a different thing altogether. But it's amenable to that challenge. You can't say that the challenge is immune.
My lord, I would respectfully submit applying or disapplying the constitutional provision would not give a individual citizen a right, because I'll tell your lordship why. This takes us back to the basic principle of this is adjusting the accession. Now, my lord, in international law, for example, a citizen can never assert that I had certain rights under an earlier legal regime, and now there is an accession, those rights should be continued. Your lordships have rejected that, consistent following the principle of international law. You have only such rights as are available to you within the territory. Now, in that discrimination, you can challenge. Today, my lord, which constitutional regime will apply in Jammu and Kashmir is more, in one sense, almost a constituent power. So, my lord, Article 14 challenge on the ground that I was a citizen, I was living in Kashmir, nobody else was allowed to enter here, now you've taken away my rights. That argument will not be open.
That's quite apart from, of course, the submission of the solicitor that by the abrogation, you expanded the panoply of rights which an individual in Jammu and Kashmir has. You have
No, I'm not taking an extreme case. Can an individual come and say, I had a right to live here, splendid isolation? You've taken away that right, and now all Indians have the rights, which I earlier had as a special right.
Your contention is that the residents' right to live in Jammu and Kashmir is not taken away.
Nothing. Their rights are expanded by applying the whole of the Indian Constitution. Nobody has a vested right in a state of governance in that sense. And Sabat and Malad 370 is a part of the Constitution where the president has a power to disapply the Constitution. If he disapplies the Constitution, how can a citizen complain? A resident of that state. As much as a resident of outside Kashmir could not say, why am I made subject to parliamentary legislation when this subject in the state of Jammu and Kashmir is not? And in fact, Malad, we used to always, I remember the late Altaf Ahmad, he used to always have a little joke. He says, you people have lost the right to property, we haven't. 19-1F continued, the equivalent continued under the Jammu and Kashmir Constitution. We got rid of property rights. Now, could an Indian complain, could a person outside Kashmir, a fellow Indian, say that my fellow Indian there in Jammu and Kashmir has a right to property? If you take his property, you have to pay him full compensation. But if I am outside Jammu and Kashmir, take my property and you can show me a blank piece of paper and there's nothing I can do.
370 now leads to the abrogation of 19-1F in Jammu and Kashmir.
It does.
But which is not a part of the basic structure. 19-1F has been held not to be
It is not as much today. If you are creating a larger equality, the solicitor has developed this point, you've created a larger equality. Where is the question of violating 14? And individuals, my lord, that principle must be extended. Your lordships have dealt with this problem, where the argument was there were prior leases. Your lordship said, sorry, post-accession, you have what the law gives you. You have nothing else. Now, if post-accession...
Actually, we need not really explore this line much for the reason that this might have impacts on other parts of the Constitution.
And that's why, my lord, I was...
The Constitution which create rights in favor of specific groups.
Yeah, my lord, that is why I limited myself.
Whether they're based on religion, whether they're based on caste, on marginalization. So to say that by obliterating that right, you're not affected by a larger equality, maybe?
My lord, 370 operates.
Argument if we accept it in that broad
No,
sweep.
no, my lord. That is why I'm saying
Getting to this,
370.
because I don't know what the ramifications.
No, no, my lord. 370 operates in a very narrow area. Very narrow area. It operates in the context of the compromise formula put in place for Jammu and Kashmir at the time of accession and at the time of its integration into India, etc., etc. And this power was kept to disapply this one provision, this special arrangement. Now, my lord, there is no equivalent in the Constitution. So we needn't go, my lord, the Chief Justice is saying the danger in getting into constitutional propositions in one context and making broader observations, my lord, we don't know what you are trampling underfoot for the future. My limited submission was the principle of limiting delegation by statute, which comes from Article 14, can't apply. This radical change is a reading down of the power to extend laws.
That point you've made, Mr. Sarve.
Yeah, that's the only point which I was making. The second point I was making was
restricted to that level. There is no difficulty.
that's all. And the second point which I was making was, Bharat, that here abuse of power is really a power of competence.
And nobody's challenged the provision of clause 3 of Article 370. That is
which Malad, in fact, brings me
part of the original constitution.
In fact, Malad, which brings me to my next point. And I'm going quickly now, because your Lordship has seen the point. That this repeated reference to basic structure, my lord, quite frankly, even in some of your Lordship's judgments, I find a little surprising. Basic structure was not a principle as an independent standalone constitutional right. Basic structure is the limitation inherent in 368. And constitutional amendments are tested with reference to the basic structure doctrine. But there are some judgments which do say this law not only violates 14 but violates the basic structure. Laws, strictly speaking, if you
laws don't violate the basic structure.
Laws can't violate basic structure. Laws violate part 3 or don't violate part 3.
You know, in 2 judgments, though, we have said that a particular law protects the basic structure. One.
But laws are aligned with the basic structure.
Places of Worship Act in Ayodhya, we said that is in pursuance of the...
Correct. But laws...
The second, we said that the amendment to the introduction of the amendment for Delhi in 239 AA was in furtherance of the basic structure, which is...
furtherance of basic structure...
So there's a little bit of...
let me try and, in my very humble submission, when a law is made to protect civil liberties, 21 is a part of basic structure. A law made to protect civil liberties is a law aligned with Article 21 and therefore aligned with the basic structure. Now, one may in a flourish of language say it is to further. Today, if there are checks and safeguards built into arrest, checks and safeguards built into criminal trials, etc., etc., you may say this is to protect the basic structure, because the basic structure is the trilogy of rights. Now, that is not to say that the law was tested on basic structure.
That distinction you've made, yes, of course, because as a doctrine, it was evolved to test the validity of constitutional amendment.
The problem is, Malad, one thing is to say something is aligned or not aligned with the basic structure. But to say that if exercise of power under 370 can be tested on the basic structure doctrine, I submit is a misconception. 370 itself is a part of the original prestige constitution. And that confers the power to disapply the constitution, the arrangement. If I am right on competence,
Anything else, Mr. Sarve, now?
So, my lord, that is the basic structure point.
Yes.
And the point which we have therefore already made, and I close with that submission, how would your lordship interpret this? The nature of the provision is such, if it confers plenary powers, not in the field of civil rights, not in the field protected by Part 3, but in the area of governance and in the area of constitutional adjustments, your lordship will give it the widest possible. Because the idea is never to hedge in future generations by reading the constitution narrowly. That is a well settled principle. Last point which I have to make, my lord, is if we are wrong on this, the 356 test. Can a change of permanence be made when a 356 regime is in place? It has two answers. I'll just take 2 minutes on this. This is no longer res integra. Your lordships have right from Rajasthan and Union of India, Bomai, chiseled this law and said, up to the stage where Parliament approves, don't do anything which is irreversible. Thereafter, you may. Because everything in one sense is irreversible. What Parliament does is also irreversible. Parliament passes the budget for the states. It takes over the coffers of the state. What money is spent is irreversible. The money is gone. But that's the way it is. The president may not dismiss people, appoint people, create institutions, remove institutions. The governor may do, the president may do under 356. Those are for those people irreversible actions. That is why your lordship has said 356 is draconian and should be very sparingly used. If the unfortunate circumstances require that for a defined period of time, the system of governance is changed under 356. If those unfortunate circumstances exist, and a very narrow area of judicial review is permissible, it doesn't arise because there is no challenge before your lordship, a bald prayer without the necessary averments, the challenge. Then, my lord, one is to accept the consequences of 356. But that's in the alternative. If I'm right on my construction, my lord, of the proviso, quite frankly, minus the Constituent Assembly, it fell away. So you just added the state legislature and then you acted for the state legislature. Nothing dramatic really happened. If one ignores that also, if we are right on the proviso, then none of those questions arise. That, my lord, is the submission, unless there's something else I could assist your lordship.
Thank you, Mr. Sarve. That could be all. Thank you, Mr. Sarve.
Much obliged.
Yes, Mr. Dev.
With the leave of my learned friends, I try to be as possible to conclude my submission. I don't want to eat into their time too. A couple of things your lordships will notice in my written submissions, page 41. I have the lordship's leave. I have a 2-page note.
Yes, certainly.
Which I have forwarded to the master. It's like a summary of my submission. No, it's been given to the.
He just uploaded. Yeah.
Before I just, it's let me open before that. The three broad reflections I want to share with the court.
It's what you called opening out.
Yeah, but before I read that, Lords will just make a note of three broad reflections. What they are. One is the history of President rule in J&K. In that regard, I have my submissions at page 41 of my written submissions. You'll just make a note of that. So three broad points I would like to place before your Lordship. One is the history, then on the scope of 356, and then sovereignty, and finally on winding up on 370. So on these three aspects, I request the Lord just make a note of the relevant pages in my written submission. At page 41, just briefly sketch the history of President rule in J&K. Lord will make a quick note of paragraph 2 of this under this heading. So I say there is no constitutional injunction barred that during the imposition of the President rule under Article 356, any measure under Article 370 cannot be undertaken. So I say they can be undertaken. So the following orders which are spelled out in the paragraph 2 are examples of such exercise of measures. And thereafter, let's just make a note of 2 or 3 paragraphs here. Paragraph 5, paragraph 6, and then paragraph 7. May just read paragraph 7. This is at page 42, my written note. 66. Because as I try to point out in the footnote that the canvas which needs to be addressed is of such complicated issue that it only put in a straitjacket. So I see in paragraph 7, well, all political choices or political action may not be free from the scan of judicial review. This would be a qualified statement. The combination or choice of measures to be undertaken by reason of the duty imposed under Article 355 and the authority always available under Article 3 of the Constitution of India will all be matters of a class of decision making and deliberation which will deserve deference and not scrutiny. May I qualify being and not strict scrutiny, if I put it like that. Then also kindly make a note of paragraphs 9 and 10 in the same sequence. Particularly paragraph 10. Page 43. And that follows that extract from Bommai, very carefully worded provisions about the political ticket and considering the political wisdom, etc. Following that, paragraphs 9 and 10. Let me just quickly read them. Bommai principles on justiciability of the exercise of power by the President may not be mechanically extended to circumstances of imposition of President's rule in the context of matters such as external aggression and internal disturbance, and more particularly in the context of the dynamics in relation to the border states. In paragraph 10, consequently, CO 272, which can be treated as a product of consolidated stock taking of decades of internal disturbance, and unrest in the state of J&K is a valid exercise of power by the President to achieve a larger constitutional and public interest aim. That's how that aspect ends. Then, on the scope of 356, kindly turn over to page 47 of the written note. I'll just quickly take a lordship through few paragraphs. Well, in paragraph 1, I talk about the preamble, and paragraph 3.
Yes.
Um, and thereafter, in paragraph 4, I'll quickly read that. On a plain reading of Article 356, it is obvious that the makers of the Constitution deemed it fit to give a very wide and extraordinary powers to the President in Article 356. Such power the President can exercise either in the receipt of a report from the governor of state or even otherwise, on being satisfied that a situation that is in which the government of the state cannot be carried on in accordance with the provisions of the Constitution, the President may proclaim any or all of the following. So, having regard to the amplitude of the powers, then kindly turn to paragraph 5. That's why in Badrinath, we'll also just make a note of the judgment that's available in volume.
Badrinath was cited by the
That's right.
solicitor. Yes.
Just paragraphs 25 and 26 of Badrinath.
Yes.
So kindly make a note of those two submissions in paragraphs 5 and 6 here. Also, please make a note of paragraph 8, where we have set out how proviso to Article 3 has been suspended during presidential proclamation Article 356. In the following case, we're given a list of all those cases when therefore it is not something a departure here. It's in tune with the constitutional practice.
Suspension.
Sorry, where is it gone?
The other things, Bommai and Badrinath, we've of course seen the solicitor cited both the
Sure,
judgments.
please.
So.
Just make a note of those paragraphs which is spelled out, paras 10
We've
to
got
13
that,
in this
we'll
note. Then I'll quickly run through this. Kindly turn to page, please revert back to page 16.
Go back to 16.
Try to talk something about the sovereignty issue, the division, and then you have the thesis that you have retained something with you.
Good.
We'll do is we'll go through the submissions in the evening today.
Your Lordship, please.
If there's some further query, then we can pose it to you in the morning.
Can I just
or
quickly
for two.
therefore take your Lordship so that 2-page note we just, then I'll complete.
This one. Yes.
I proceed to read it. Where is it? Okay. Where do you put it? This thing. The process of constitutional integration of J&K bears all the resemblance with the process of constitutional integration of various territories of India, namely democratization combined with the merger of small states, formation of union state, the idea of having constituent assemblies for framing constitutions, etc. There was no distinct or special compact between Union of India and J&K as far as the constitutional integration process is concerned. The political compulsions which intervene in the case of J&K resulted in the formalization of the process of integration as enacted in Article 370. This formalization of the process has no flavor of a distinct special or a special compact, the object being constitutional integration.
But surviving is
May proceed. Then 2, various 3 is about Article 317 on behalf of the petitioner, the self-serving propositions away from the text and context of the provision and the intent and content of the provision. The context, namely the deliberations required for the extension and applications of the provisions of the Constitution of India and J&K to J&K in order to suit its needs and requirement and its ultimate constitutional integration is the object of Article 370. This process is expected to be completed in the course of deliberation by the Constituent Assembly at one level, having regard to all the constitutional orders issued before 1957 and Section 5 of the J&K Constitution. It can be stated the process of integration was complete. At another level, taking stock of the issuance of constitutional orders by the President beyond 1957, the majority of which is in the nature of constitutional updating, it can be stated the updating has been perceived as a continuing link. It is open to the President to take a final stock of the exercise authority under Article 371D and to decide as to whether there is a need of updating exercise at all or the need for any other invocation of Article 371D. This power of the President is not limited or conditioned by any practice in relation to Article 370 in the past. All propositions relating to sovereignty, external or internal, divided or shared, are completely inappropriate in the context of J&K. There is no distinction between constitutional integration and assimilation of J&K and the other parts and territories of India which integrate the Union of India. There is no basis for an artificial line drawn between internal and external sovereignty. All statements about federalism are based on political practice. What matters is the arrangement of powers and authorities in regard to the units of the federal structure. Once the arrangement is drawn on the basis of submergence, If any attribute of sovereignty is only the arrangement to be looked into, there can be no room for any subsisting elements or attributes of sovereignty thereafter. Part 18 of the Constitution of India is a composite scheme calling for its flexible application, having regard to the fundamental mandate of securing the integrity and unity of India. The application of provisions of Part 18 in the case of border states and the appreciation of factors to be reckoned in the regard will not be justiciable. It is open to the President and the Parliament to act both under the scheme of Part 18 and the plenary powers under Article 3, which is not conditioned by the provisions of Article 356. No rights in relation to representative democracy have been taken away. Reorganization of states include temporary or other rearrangement rights to serve the integrity of federalism and the unity and integrity of the country. All rights are available for exercise only if the unity and integrity are intact. The doctrine of necessity is flexible. The long history of internal disturbance, lack of availability of real measures of rights and justice are matters that can be legitimately taken into account for paving the path for due course rearrangements. No person can have a vested right in favor of a perennial state of unrest, and all instruments of law which have not subserved peace and justice have no inherent justice right to exist or continue. However, it is submitted that all measures taken within due process are granted and to be pressed into service to act in exceptional circumstances. That summarizes the submissions, and you'll also I'll give a skip note onto my written submission to indicate which part probably will come in a certain sequence. I'm thankful to your Lordship's kind indulgence.
Thank you. Thank you.
So let me begin with a deep breath. 14 days of wait, and with some hiccups. Finally on the pitch. However, my lords, we are dealing with Kashmir, my lord. If one goes to Kashmir, my lord, 14 days are not enough. I think Mr. Zafar, I will vouch for that. And even a month will be, my lord, less. There's so much beautiful scenery and so much beautiful and nice people, my lords. And a nice culture. So what one thing is there, my lord, with this proceeding, the learned counsels, what name? When you play a match on the pitch, then you don't watch the scoreboard. Oh, you forget it. So one thing is clear, my lord, that the learned counsels on my right, my lords, they have very ably, my lord, put forward the case for the rights which the people of Kashmir, or at least some of them, feel vest in them, and the desire to see the continuance of 370. Nobody can say, my lord, that the lawyers who are not from Delhi, they have taken full care, my lord, of the interests of those who believe in the continuance of 370, and even the world who is watching should see, my lord, that the emotions with regard to Kashmir are not only running in the veins of people of Kashmir, but the whole of the people of India. They are concerned with Kashmir. One way or the other, that's a different matter. Which way the judgment goes is another matter. But we are all concerned with Kashmir. That's the stature of Kashmir, not in the hearts of all the people, not 1.40 crores. Lord, the other aside is, Lord, that I was wondering, Lord, taking a cricketing analogy, just a little aside, Lord, that when we walk into the pitch, the opening batsman, Lord, is one finds with the guards and thigh guards and elbow guards and helmets nowadays. But our Lord, opening batsman, Lord, the learned Solicitor General, when he walked up, he did not walk any pads, etc. And that reminded us of the period of Sunil Gavaskar. We never had wear the head caps and all that. Only the skull cap was there. So he didn't start by saying that these constitutional orders carry the presumption of validity. These are all available to the state to stand up and say, which your lordships, of course, keep in mind. One, that there is a presumption of validity, which they have to, the burden is on them to show that unquestionably, undoubtedly, the only conclusion is what they are conversing for. The second principle, is that if there are two views possible, with regard to 370 sub Article 3, then that view should be adopted, which sustains the exercise of power rather than it defeats that exercise of power. So the burden on them is to show that what they converse for is the only view possible.
Mr. Dwivedi, which I are you appearing in? I'll be just like.
I'm appearing in writ petition 1070 of 2019 and IA number 84479 of 2022. I apologize. In writ petition 1070 of 2019 and writ petition number 1162 of 2018. Both of them are by the most popular PIL petitioner in the court today.
Ms. Manohara Sharma.
No, listen. Nowadays he is not that popular, Mr. Upadhyaya.
Oh.
Your arguments, Mr. Dwivedi, have to be very brief.
My argument.
Arguments have to be very brief. Because Mr. Upadhyaya feels that a delay in justice is occurring, so therefore there must be very, very concise arguments and finish. That's his view in public domain.
In fact, one question which has troubled all of us is when my Lord the Chief Justice asks how much time you will take. So, now being towards the end, it won't be too long, but let me see how crisp I can be. So these are the two fundamental basic principles. And in constitutional matters, it's always possible to take two views. Even if the basic structure doctrine was 7:6. So these are all always highly debatable. Ultimately, your lordships have to decide which is a better proposition to take place. Just as in that case, what tilted the balance was that if an absolute power is granted to amend every part of the Constitution, then many of the fundamental values can suffer destruction. So therefore, that caused the tilt. But there also, your lordships did not say basic structure cannot be touched. It can be abridged, but not destroyed. That was the concept. So coming to 370, lords, I have some divergence from what Mr. Salve submitted. It's not in opposition, my lord, to what he generally submitted, but some divergence. Yes. In our camp, my lord, fortunately, there is little divergence and contrast. Unlike, because those who are claiming that that's the only submission, I find a lot of contradictions amongst the lawyers stand. Some saying something, something trying to say quite opposite to that. But that apart, my divergence is about the character of the power of the president. Mr. Sibal said it is executive, president's power. Mr. Salve says it's legislative. I say, my lord, that this power is a constituent power, much wider than Article 368. The fact that it is vested in the president is for the special reasons which existed when it was framed. It's a constituent power. A power, because the lordships in the 5 judges' judgment say, Puran Lal Lakhanpal 2 probably, that modify is very wide. Efface. You can say even 136 will not apply. Ordinarily, independence of judiciary, if anybody touches 136, it will be struck down as base, violating basic structure. So the power to modify and accept under D is very wide. Well, there are 5 kinds of constituent powers in the Constitution.
Yes.
The first was the original constituent power in exercise of which the Constitution was framed. The widest term, you could have framed anything you wanted. Whatever kind of federal structure you wanted. The second one is the ancillary constituent power. That is something looks like Article 238 was that for certain period of time, the federal structure stands suspended. The central government will control Part B states and develop those structures and ensure that it comes up at level. And that's very important. It doesn't apply to Kashmir, that's one thing. But the idea was that the central government should take steps to bring it up at par, those states, Part B states. The other was 306 in the chapter of free trade and commerce, where certain states were very much interested in continuing with the power of taxation, particularly Travancore, Cochin, because being on the port, their entire income was found based on the export and import duties. So therefore, 306 permitted for a certain period those states to impose, levy and collect tax. The 370 is another power, my lords, of that kind. All three, the purpose is to have some time period, some temp period, so that bring it to the level of the normal federal level. Asymmetry, my lord, is completely different concept. Some tribal area may be lagging a lot behind, some state may be lagging behind, some state may have some special features, so you may for some time allow them certain special treatments. All these detailed provisions which are read out to your lordship, Lord, 371 G2, dealing with the Northeast and Andhra Pradesh, Mizoram, etc. They have nothing to do with bringing at par. That is to protect the tribals and so on. But these three articles will not stand on a different footing, and their objective is to give a certain breather, certain time, so that in due course, of course, the manner of alignments, how it will be brought in are different. So
Article 238 was not limited in time, right?
no, but ultimately by 56 it was
Right. It was
intended to be a permanent feature. That's what I mean to say, Rose. Under the policy documents, which I will read out to your lordships to the relevant portions only, would show that the idea was because the different Indian states were in a different state of development. Some Malad was so small they could not hardly afford to have a legislature, etc. I know. So state structure could not be supported by them. So like even in Himachal Pradesh, they had to be collected and put in one. So many union of states had to be carved out. Many small states had to be just merged. They could not afford to have a state. And though even those who formed a union, they hardly had a constitution. That it required a time period to build a constitution for the United States. So for various reasons, in various phases, things developed. And so finally, the federal structure which was formed, even at that stage, there were pulls and pressures. So certain compromises struck. And these three articles, therefore, Milord, are ancillary constituent power. They are continued. This is very significant, Milord. With the process, for example, for 370, the process which started with the framing of the Constitution, it was understood, Milord, that this is to last. They don't fix a time period, though they have put it in part 21. No specific time period is put there, but it is expected, Milord, that in due course, as Nehruji and Guzari ji said in their speeches as prime ministers, that slowly B1, B2, and D will be used, and the alignment process will happen, and slowly a time will come where really nothing remains. Then put them at par and finish it off. This is meant, therefore, to slowly align it, bring it at par, and terminate it. So it's that continued process, and that's why it's an ancillary constituent power. The third is, my lord, the amendatory constituent power in 368. And in the context of 368, I will just give your lordships the paragraphs, not separately, lords, of the different judges, lords, who held that the power under 368 is constituent, lords. And that's why Golaknath was overruled, lords. Though ultimately in the process, lord, what was created was the super Golaknath. So the limitations were in Golaknath were only fundamental rights, but now, lords, it's a much wider domain. Essentially, what I rely upon on those portions where the ordinary law and the constituent power have been distinguished. And the distinction pointed out is that where you are amending the constitution, constitutional provisions, then that power is constituent power. Ultimately, 368 so therefore, and if you compare 368 and 370, located in the Constitution in proximity. The width of amendatory power, at least as the law stands now, basic structure cannot be amended there. But here, so far, nobody has paid any heed to the basic structure. 35A has come in and a whole lot of things. 136 was applied much later. So, Comptroller Auditor General came much later. So, all the basic fundamental features, they were missing. So, it's much wider than the amendatory power. So, it cannot be described as an ordinary executive power of the president, or even a power which is legislative in the nature of an ordinance making power. So what your lordships deal with today is a constituent power. And this constituent power, Lord, is laced deeply with elements of act of state. To illustrate, Lord, Article 370, sub-article 3, if the proviso was not there, which lasted for a few years from 51 to 57, then it is nothing but an act of state. Anytime he could have said end to 370. So the constitution makers, instead of leaving it for the state to act supra-constitutional to annex the state, they provided a particular procedure to avoid that happening, so that it happens as far as possible, with concurrence, consultation, recommendation, and a period of time lapses when, it is felt by the people as a whole in the country that the time is ripe. That's what Iyengar said. When the time is ripe, Jammu and Kashmir will stand at par. So who decides when the time is ripe? 373 will not continue because of emotional reasons, sentimental reasons. As my Lord Justice Gawai had said, this case can't be decided on sentiments. Sentiments are on both the sides and of variety of kinds. So those sentiments have to be kept outside the door. It is the president, and the president means the council of ministers and ministers who are collectively responsible to the parliament.
Do you call this ancillary constituent power because the president has the power to amend the constitution and its application to Jammu?
I say ancillary only for this reason, that it is a continuation of the process which began with the insertion of 370. In that sense, I am saying ancillary. Otherwise,
but it's constituent according to you because any power by which you can amend the constitution itself.
Yes.
Because it says that the president can, can determine which provisions of the constitution shall apply with exceptions and modifications. So the president is vested with the authority to apply or refashion the provisions of the constitution in relation to the state of Jammu and Kashmir.
That's right.
Concurrence is a separate issue.
That's right.
Therefore, it partakes of a constituent power according to you.
That's right. So not only what the Constitution of India will be in relation to Jammu and Kashmir, because on that depends what the constitutional ambit will be of the JK Constitution. As the Lordships had pleased to observe, based on their own Constitution of Section 5, as this expands, that contracts. So therefore, this power is having a direct impact on the reduction of the scope and ambit, the play field for the JK Constitution. So it's not only an unusual power, but a power which is of a very wide scope and wide impact, wide consequences, wide ramifications for the whole of the country.
Very significantly, any modification cannot be brought about by the legislature of J&K or under the Jammu and Kashmir Constitution.
Right.
Modification has to be brought about within the rubric of the Indian Constitution.
Indian Constitution. That's right. And one of the proclamations, the first one of the Yuvraj Karan Singh, as he then was that this Constitution of India will define the relationship between the state and the union. 25th November 1949. That's very important. I'm not reading it, you'll also have seen that. JK Constitution was not there. So this Constitution will define, that's a very potent expression, Malad.
It is.
So therefore, Malad, it's not an ordinary legislative power and I'm so sorry.
Two of the unit. Say if entry 82 of the union list is applied, the J&K, there's no provision in I just took 82 not for any reason. I picked up one entry.
Yes.
That there is no provision in the J&K Constitution by which they can say that, look, we don't want 82 hereafter.
That's right.
Because the application or non-application of provisions of the Indian Constitution has to originate within the Indian Constitution.
They are asking for anything is insufficient, inconclusive, of no avail. Of course, I'm not belittling it, but after all, one state and union relationship is involved. If a state is asking for something, certainly the union should consider and give it a thought and possible accept. But that's a different dialogue. It's not talking and speaking to each other as Mr. Gopal Subramanian was saying, and lot of talking and speaking and whispering also goes on in political sphere, in every law when it is made. Sometimes they meet outside in the lobbies and sort it out. Sometimes it goes to select committees and so on. So talking and speaking and whispering and all that is neither here nor there. That doesn't result in a compact. If something, two parties go outside and sort it out and then the bill is passed with some change or without changing. What happened when 370 was being tabled? Your Lordships has seen, there was hardly any discussion. Because the government said that do not debate too much because the advantage will be taken by the warring state across the border before UN. There was no debate. And in 1952, Mr. N.C. Chatterjee said that at that time you did not allow us to speak, saying that Pakistan will take advantage of it. But now in 52, then he put up questions. Of course, Nehruji answered it. These are only not critical of anything like that one has to place oneself in those times, and it is difficult for us to go on a flashback in these cases. They're difficult times. So he answered it then, but those questions were not put. So one can't put reliance on the speech of Mr. Anger or this or that speech of Mr. Sheikh Abdullah. They were divergent interest also, clashing interest also at that time in play. It doesn't detract from the stature of any of the political leaders. Sheikh Abdullah was a great personality, political leader. Nehruji was a great leader. Sardar Patel was a great leader. But what of that? Churchill was a very great leader. But after the Atlantic Charter was hashed out on the seas with President Roosevelt, when he was posed with the question, what about India? He said, this charter doesn't apply to the India. They are colonies. It is only meant for France and Poland, etc., in Europe, which lost freedom and their territory to Hitler. So they're all great leaders, but they grapple with their situation in the interest of their nation. And in this case, when 370 was being drafted, please bear this mind, my lords, these circumstances which were prevailing then. And one more very vital circumstance. We have been hearing lots, and sometimes I've read through the Constituent Assembly debates also, many books also. They all said war is going on between India and Pakistan. What was that war, Mulad? Somehow, Mulad, we are still, the lips are pursed and we don't want to speak about the truth. Who was the Supreme Commander, Mulad, of the Armed Forces? Lake. All the three generals of India were British. All the three generals of Pakistan were British. What was this war, Mulad? Churchill had designed there itself that India has to be partitioned. Geopolitics. This war was a British war. They created it on both sides. The raiders came from where? Northwest Frontier Province. After 2 terms, Mr. Cunningham, who had been governor in Northwest Frontier Province, he was brought back in July, just before the elections, referendum. The raiders were trained, sent on trucks with weapons of army. Pakistan army had just been split from India. And the biggest, starkest example is, Lord, who was fighting, Lord? What is this POK today? 2/3 of POK is Gilgit-Baltistan. And who fought the war there, Lord? Not the raiders. It was Major Brown, who was the regent there. He was posted again in July, just before that, by Cunningham. And this is a book, Lord, Mutiny. He killed all the forces of Maharaja. Ansar Ahmad was posted there, Lord, and he was arrested. And he, in 4 days, Lord, he hung the flag of Pakistan and he handed over to Cunningham. He sent some Mr. Alam from Pakistan army and he took over Gilgit-Baltistan. Where is the war with Pakistan? It is British. But if we close our eyes to all these, then it is the raiders fighting across floods. Raiders could not by themselves come up to Srinagar. The war had reached almost this Kardu and Kargil and to that closeness to Tibet, Leh. So it was a war of a different kind, but nobody could say it because Mountbatten was there, Lord, as the Governor General. Again, must have the leaders, our leaders must maybe having some reason that even though Lord Jinnah said, I will not accept any British Governor General, but the party said, no, we are ready to accept Governor, you continue with Indian Governor General. So what is this war? Governor General, and not only this, when the war began, Lord, they constituted a defense committee of the cabinet. And Mountbatten was made the chairman of that. So it's an excellent situation. Lord Mountbatten is the chairman of defense committee. Auchinleck is the supreme commander of forces. All generals are British and one Britisher is mutinying, and when he returns to England, he is given the medal of the British Empire. So that's not the position of the war. So when you read the Constitution and 370, please bear in mind these things, in what circumstances our leaders were moving through. And when we were about to push them back and recover the territory, they deliberately stopped the war at a point of time and got the reference to the United Nations. Because if you had gone up to Mirpur and behind, then that connection would have been off with Gilgit-Baltistan. Now, these are hard facts, nobody can dispute it. It is in these circumstances, Lord, and what was United Nations? The same very power which for geopolitical reasons, the US and UK, which wanted to partition India, they were the arbiters. Fortunately for us, Lord, Pakistan refused to vacate POK. So that resolution is dead. There's no need talking about United Nations, but at that time, look at the enormity of the situation in which 370 has been. We can't interpret it, therefore, Lord, with a tool of interpretative toolbox. Maxwell cannot answer this. Bennion cannot answer this. Grace cannot answer all this. None of the judgments so far which have been delivered in this court are helpful at all, Lord, to reach a conclusion, except Sampath Prakash, Lord, which dealt with to some extent with the situation after the expiry of the dissolution of the Constituent Assembly of Kashmir. That and that alone. The rest are all in different contexts, principles we can help, take help of. But this situation, if lost sight of, creates problems, Lord, at both ends. You accept their contention, then this becomes permanent. There is a proviso under 368, we can't amend it. Go by the route of 370, and 370 is permanent, and therefore, Lord, we are left at the mercy of the local vested interest, which does not always coincide with people's interest there. So you, therefore, look at the consequences of both sides. On one side, if you accept our submission, the right of the people of Jammu and Kashmir gets expanded. And they don't suffer blood. Right to property is a matter of the rich and the neo-rich blood. The poor people, they're hardly 19(1)(f), they're hardly concerned. But even those smaller people who have small houses, etc., so certainly it has meaning. But then 300A is there, which virtually subsumes, now it's a human right under the Constitution. So nothing is lost, not even 19(1)(f). Nobody can confiscate because of 300A. So 31 and may not be exactly at par with 31, but substantially it is there. So nothing is lost. They are put at par. The basic structure of federalism is protected. I don't know how a lot the submissions were made that federalism is affected, to keep it in mind. This is federalizing at par.
According to them, federalism is affected because you reduce the level of a state to a union territory.
Unless you accept asymmetry is basic structure, then they are affected. Asymmetry is never a basic structure. They are for special conditions. Asymmetrical dealing with a state.
Mr. Dwivedi, this matter apart, the existence of a state is a very vital element in the federal.
I'm not on the state.
The existence of a state, the continued existence of states is integral to federalism in India.
Well, sir, I will humbly request your lordships, I'm dealing with CO 273. 272, which deals with 356, that has been answered by the Solicitor General, or whatever, your lordship will consider that. Supposing, my lords, for a moment, for my submission, please assume, my lord, that 272 and the act is not there. Because it's my case, what I am conversing for is, irrespective of 356 invocation and Article 3 invocation, 273 is sustainable on the anvil of 370 main part itself. It says that Parliament has recommended and we are passing this. Obtaining the recommendation of
consume tomorrow. So they will.
So far as involvement of Parliament is concerned, it comes in two ways. One is
Mr.
the
Trivedi, just to sort of break your leg a bit, you spoke of there were 5 constituent powers.
the fifth one I have mentioned.
We got third. We have the original constituent power by which the constitution was
The
framed.
fourth.
Second was ancillary constituent power. The third was amendatory constituent power. That's the third.
The fourth, my lord, is like the provisions like Article 3 and 4, where amendment of schedules relating to states and their structure, etc., Article 3 and 4, they can be altered. And by a law of Parliament, and it is provided that they are not to be treated as amendment under Article 368.
Then can that be treated as a constituent power at all if it's not an amendment to the Constitution?
No, so they are amending the schedule to the Constitution. Their levels are different.
But the Constitution tells us that it's not really an amendatory power.
So therefore, I'm saying that these are the 5 different ways in which the power has been conferred. This is one another way
All right. That you
where
just
they
sort of
say that
articulate.
you can make a change in the Constitution. Because my postulate is that every change in the Constitution itself, if brought about, is a constituent power.
All right. That's the fourth.
And the fifth is, my lords, Article 1C, where this court has held that if you acquire some other territory, then it says I'm sorry, Article 2, my lord.
Two, not two. Yes.
2. I'm sorry, it's Article 2.
Parliament may by law.
Yes. Admit new states on such terms and conditions that things fit. Again, my lord. Very wide. So while admitting, my lord, A, B, or C country, let's say, my lord, some bordering city of China, my lord. They are very interested in naming our cities, my lord. So if that is admitted, just aside, my lord, lighter way. So if it is admitted, my lord, then the terms and conditions can be fixed.
Therefore, your argument is that the exercise of the power under Article 370(3) is a constituent power exercised by the
So
President.
your lordship's judicial review has to be on that basis. And it's when your lordships expound 370, it has to be with that in mind, my lord.
So the level of deference would be much higher than even the level of deference to an ordinary piece of
Ordinary
legislation.
piece of legislation. Executive order, then Wednesday principles and all those things will come in. Whether your lordships will bear judicial restraint, that's the other side of it.
That's the exercise.
Yes. If it is legislative, as the lordships put, my lord, Article 14, how it will come is whether it will succeed or not is quite another thing, but amenable is the lordships. But if it is constituent power, my lord, which is continuing and is part of the constitution making, part of federalizing. This is part of constitution making, part of federalizing Jammu and Kashmir at par with other states. I will read 2 state policies, one place before the Constituent Assembly by the State Department and the other the speech of Sardar Patel, where they spelled out the policy. This was a departure from that policy. And departures, my lord, are not permanent. Can never be permanent. The policy is states, that is the Indian states and the British provinces under the Government of India Act should be brought at par, at equal level. That was the policy. and placed in October and November 49, just before the adoption of 370. So 370 was a departure being made because of circumstances, political pulls and pressures and so, and the circumstances which I narrated. So therefore, you have to therefore consider this as a continuing process which was meant to be terminated, and 75 years is a pretty long time for federalizing Jammu Kashmir at par with other states. That means that the power was rightly vested in the president and was properly exercised by them. It was not that in 1957, one may ask not that if my contention is accepted, then immediately after dissolution of JKCA, the president could have terminated. Yes, he could. It's a high political policy. It's an act of state. There were some states where forces were sent. That can't be questioned, that how Hyderabad was brought, how Junagadh was brought in, how a referendum was done. All those things are in the past and they were act of state. Mr. Sibal said that had there been another route, act of
An act of state is executive, right?
So executive, nothing prevents the Constituent Assembly from putting a power in the Constitution itself. So that, it is what was expected was that the Constituent Assembly, when it sits, it might well take a decision that please align us at par. The recommendation, part of it, the proviso, was merely to enable the JKCA to look at the advantages of the federation.
Deveri, what was pointed out by the other side was,
Yes,
when you frame the constitution, when you enact the constitution, then you're probably exercising constitutional power. What happens thereafter will be either in the realm of legislative power or the executive power. If we go by this.
so that's not right, my lords. And that's my contention. They are not correct in that. It's not always, then 368 law is not purely legislative and executive.
Now, you are equating 368 also to constituent power. Yes, by saying that it is also a constituent power. That way it is. Whenever you will be amending the constitution, you will be making changes in the constitution. But that exercise cannot be equated with the constituent power for the simple reason. Constituent power has the power to go from a scratch, from 0 point.
Not necessary, my lords. A mandatory power is constituent.
Yes, a mandatory power is certainly
So this
there.
is a mandatory, my lords, look at much wider.
No, the question is not that. The question is, can the mandatory power under 368 be taken to the level of constituent power as to go?
I never said that, my lords.
You're not saying that.
No.
So what you are saying,
s-
therefore, they're really speaking, there's jurisprudentially, there won't be any difference.
There would be, my lords. The nature of power is completely different. Lord. That has to be realized. An executive power of the president is, for example, he recommends, my lord, financial bill should be passed. That's a different kind of power.
That's correct.
So the president has a whole lot of role to play under the constitution. All roles are not at par. For high policy reason, this was given, my lord. No, but this proviso to 368 is because the government, my lord, of India did not want, my lord, to go through the route of 368 every now and then. So if you want to, my lord, do away with 370, go to 368, then 2/3 majority, and then maybe somebody will say state is affected, so ratification by majority of states. So an easier, my lord, because the policy was to put at par. Therefore, my lord, it was, since the policy is given, alignment is the question. Alignment may take such time, my lord, as the circumstances permit. Nobody can predict how much time it will take. So, and this was provided here. Keep also one more aspect in mind, my lords. The framers of the constitution knew that a president of India is a continuing office. It will not lapse after any point of time. Whether it is part of basic structure or not. But Even if it is not, nobody expected that the President of India office, high office in which the executive power vests, will vanish. So it was a continuing power. They also knew that Jammu Kashmir Constituent Assembly is an ephemeral institution. So they had two institutions, one permanent, one ephemeral. They are being brought into a relationship in 373 with a notwithstanding. So now not an ephemeral expiry of an ephemeral institution impacts the permanent institution of the president. That can never happen, my lords. If that were the intention, what was so difficult in 370 for to add a few words that with the expiry, my lord, of the JKCA, if I may use this short JK Constituent Assembly, then, my lord, the main power will also lapse. The framers are very well aware of cessation of certain exercise of power after certain period. Be it 356, 352, ordinance making power, place in 6 months. If you don't place, it will lapse. My lords, have dealt with Lord Krishna Kumar Singh. Even 249. So there are so many lords situations. They are aware. They are casting the languages of different provisions with this expression that it will cease for different reasons in different cases. Why is it that they are refraining here? Certainly, my lords, it could not have been in their mind, my lord, that this will remain for all times to come, my lord, till eternity, my lord. The relationship of Jammu and Kashmir, my lord, state as a federal unit with India will remain different for no reason whatsoever. And as my lords had put a query to them, if I may just adopt that. Supposing, my lords, through the route of with concurrence and consultation, my lord, everything has been adopted. Why do we want to keep this relic? For sentiments, my lords. So it has to go someday, my lord, somewhere. And what is it that remains today, my lord? It may not be a shell, but close to a shell. And my learned friend Zafar Shah said, my lord, we have sentiments. Yes, we understand that. If I live for too long, my lord, with a particular provision, my lord, there will be sentiments, my lord. No difficulty, my lord. We appreciate that, we honor that, we respect that sentiment. But equally, just a human life, my lord, the time comes when you have to bury it. We have emotions, we have sentiments, but we have to bury, my lord. We have to cremate. So that's what, my lord, is in mind, my lord, that please, therefore, my lord, your lordships are acting as a part of a constitution making process. This adjudication is not apart from, my lord, completely disjointed and disregarding that process. Host of other things your lordships have already noted, my lord, this temporary here, temporary that. Right? They say marginal note, somebody says temporary is only object, my lord, not the time period. This is not the way, my lord, the lordships in Bombay have construed. Sometimes the lordships take help of the marginal note, sometimes the lordship doesn't, my lord. But here, my lord, the conglomeration of 370 along with all other provisions originally there. I'm excluding the special provisions. All the provisions were temporary. Somewhere, my lord, time period was fixed, somewhere time is not fixed. But all intended to lapse. There are temporary provisions elsewhere also, like 306. So they are meant to go. Don't hang on it. Nobody hangs on, my lord, a body which is just a shell. It causes only those some. I can understand people with good intention. They respect that emotion. There will be a host of other people, Lord, who will take advantage of that. And in Kashmir, they have taken it. There have been time and time again calls for plebiscites, independence. In fact, in 1964, Lord, just before his death, Lord, the Prime Minister Nehru, Lord, he had sent Sheikh Abdullah brought him back as Chief Minister, sent him to Pakistan with a message that you be a bridge between India and Pakistan. And he was going to POK when Nehruji died. Unfortunately, he expired. So I had to return from here. But I mean, that emotion which is created at that time in 52, 53, why will a person be kept in a jail for 18 years long? He suffered, yes. He contributed to India, but he stood also with his own emotions. We all respect all those emotions. Nobody condemns any emotion in human life, in a nation's life, in a state's life. These emotions arise and die. So, for emotional reason, 370, I think it's time to bury, and that's what was intended when the framers brought in 370, and that's how it is. 373, therefore, not CO has to be upheld. Now look at it once more. We are like 7 men and the blind men and the elephant. So we are all putting our perspectives before lordships and lordships. We will kindly receive that and find out what is the whole, integrated whole.
Seven this side.
7 is a small discussion. The lordships have been putting a question. So far as JK Constituent Assembly is concerned, there are only 2 provisions. 372 and 373 proviso. In one, JKCA doesn't come. As my Lord Justice Khanna had pointed out, it is between executive and executive. The president and the government of state. Now kindly see, why is there, my Lord, a difference between the language of 2 and 3? The first point is, my Lord, that the proviso refers, when it refers to Constituent Assembly, my Lords, of the state, it refers to clause 2. Recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary. Now, Sampath Prakash has very positively held, my Lord, that that is dissolved, matter ends, power continues. Now, it is the same Constituent Assembly which is contemplated in the proviso, not different. So, on a parity of logic, my Lord, that judgment, the reasoning of that judgment, of course, they were dealing only with 2, not 3. So, in that sense, it is different. But the logic on parity of law is available. And therefore, I submit, my Lord, that that concludes the matter virtually. Sub-article 2 is dead, defunct, but sub-article 1 continues. That is Sampath Prakash. Likewise, proviso is defunct. The main part continues. And my Lord Justice Call has, my Lord, in that Shah Faisal case, applied stare decisis. The doctrine of stare decisis, of course, is not an absolute principle. But in this case, an attempt was made. Without success. Now that apart, not kindly see why 2 says if the concurrence of the government of the state referred to in 1B2 or second proviso be given before the Constituent Assembly for the purpose of framing the Constitution of India is convened, it shall be placed for such decision. The word is decision here. That's right. Why it is decision there and recommendation here? Perhaps not. There is one reason which I wish to place, and if it commends to your Lordship. It is decision here because, my lord, what is being considered by the assembly is the concurrence given by the government of state. Concurrence, if your lordship comes back, my lord, to the first to B2. Such other matters in lists with the concurrence of the government of the state. The concurrence is of the government of the state. And the decision is to be given with regard to the concurrence. No decision is to be given with regard to the order passed by the president. The presidential order, whether it collapses because of the decision, is a question which is not arising, hypothetical question. But the decision is JKCA is a superior body to the government of the state. Therefore, the word decision has been used. When an order passed by a subordinate goes before the higher authority, then it is either a decision or an approval. The concurrence of the government of state of JK goes before the JKCA. Therefore, the expression used is decision. But when it comes to the proviso to 3, the president is not subordinate to the JKCA. He exercises the sovereign democratic power of the Republic of India, which is constituent in nature. There are 2 constituent powers in play. One superior, one subordinate. Therefore, the expression is used as a recommendation. A recommendation of a inferior authority, when it goes before a superior authority, can never be binding. That also if the body is a temporary body.
So according to the word recommendation in the proviso, refers to the existence of a recommendation and not the nature or the content of the recommendation.
That's right. Because I'm putting a question to myself, not supposing the JKCA had recommended a particular provision or particular structure for the executive or for the legislature of the state. Or let's say suspension of fundamental rights. Will it be open to the president or not as a constituent body to say no? How can it be forced upon him? Had he said you will suspend, delete part 3 for Kashmir? Hypothetical. Part 3.
Hello? For about a little while, there's a matter before Justice Call sitting in a 3-judge bench. That won't take very long, and thereafter we'll resume immediately. Then, as soon as that
5-10 minutes.
immediately,
We'll be here. We'll be here.
as soon as that bench is over, we'll continue.
How much time will you take more?
Hello?
How much time more?
Oh, that's what I said in the beginning. Was the most
very
difficult
tough
question. I would say, stop me when I'm repeating.
No, Mr. Dwivedi, don't put that burden on us. I can't ever exercise that.
It's a
We leave it to the conscience of the lawyers to be satisfied that you have made your points. In
I won't take I'll try to be and we are our batsmen are very few, so we will
But none of your batsmen are tail enders. They're all top order batsmen. See.
My lord, we would like to believe.
Accepting me,
Especially when it comes from your lordship at 4 p.m.
All right, after Mr. Dwivedi, it will be Mr. Giri and then Mr. Jetnani. Guru. Don't say how much time. We'll just.
This is what we are for those we are 4 petitioners who have filed.
So please do adjust time so that by lunch tomorrow we'll be done with this side.
Tomorrow is not possible.
I'll take 1 hour because I'm appearing in one inspection.
Sorry, not possible.
Take half an hour.
No. So you'll just come down from 1 hour to half an hour in 5 seconds.
Because we are dealing with an argument spreading 10 days.
My lord, say, could it be possible? We'll of course, my lord, curtail our time for tomorrow, but your lordships are giving us time till 1 o'clock. There are some persons, my lord.
We have taken only 4 days, bro.
I thought he said he's going to get them till Friday.
The learned Attorney General says doctrine of proportionality should be applied.
8 to 9 days.
No, more than that.
8 to 9 days.
More than that.
10 days, right?
10 days. Sorry. He probably has to go off somewhere.
Today we are on the 12th day.
The petitioners are given 2 days time to rejoin your lordships.
They already in the first round.
So what we can do is that Mr. Dwivedi, we'll give you half an hour tomorrow. Then Mr. Giri, Mr. Jetmalani and Mr. Guru Krishna Kumar, 20 minutes each. So 1 hour between the three of you. Half an hour for Mr. Dwivedi.
Don't give us at least half an hour. And we want to stick to the timeline. It is not as if your lordships gives us a time frame and then we keep exceeding.
We will not be repetitive.
Go into a stream of.
No, please don't curtail us now, because if your lordships feel that we are repeating anything,
We are
then
never doubting your ability to make points for even a couple of hours thereafter. We're not saying that, but we now have to bring it down to a close now.
Between 30 to 45 minutes, definitely not beyond that. And this, my lord, systematically over the last 1 week, we have been pruning our submission so that it stays within the time frame.
Let me continue tomorrow.
30 minutes extending to 45 minutes is a real question.
No,
maybe 20 minutes.
Lord, I personally, I won't exceed 30 minutes.
When you start with the assumption of 20, you possibly
Their
go on to 25.
calendar took 2 hours. Bro.
I will subsidize their excess time.
That's fine. That much we give.
My lord, could your lordships kindly give us half day on Monday?
We'll
And then,
see.
my lord, your lordships may hand over the bench into.
We'll see. Also, we'll see.
Be grateful.
Don't exceed 30 minutes. Don't exceed 30 minutes. Don't exceed